Time clock. Who's for the department?
Department Malur comment they are represented. They have filed the affidavit, Malur, we need to file.
It is not a part of the record. Okay, right. Mr. J. Barbuya, learned counsel for the petitioner submits that the respondent number,
Oh, official, I am the.
that the state respondents have filed affidavit in opposition. And that he would like,
Regional.
how much time?
2 weeks.
He would like 2 weeks time to file a reply. That is allowed.
Respond number 1 is filed the affidavit.
Respond number. That is not in the records.
Lordship, it is filed on 29/5.
Full stop. The prayer is allowed. 2 weeks time is granted to file reply. Full stop. Ms. M. Bhattacharjee submits that affidavit has been filed by the respondent number 1 on 29/5/23.
Yes, sir.
Full stop. However, the same is not on in the records. Registry to place the same in the record. This is the matter after 2 weeks.
May please your lordship, my lord, may pay for listing of this matter, my lord, on file on 13 matter released to my lord.
What of the race is it?
Matter released to my lord, stipulation of age for minimum age for Gaupura amendment. We have challenged the notification matter.
So,
So matter may be listed.
new matter.
New matter, madam, on Monday, madam.
May please, your lordship, with due consent, I beg to mention item 37 here also.
Yes.
Can be listed after next week here also.
Why?
So, K. Chaudhary, senior counsel is appear for respond of 1 is out of station here also. For respond number 1. I circulated the agenda yesterday here also.
What is this matter?
The state has filed the review your lordship against the lordship order passed by your lordship. Giving the passing the direction giving appointment to the respond number 1 here also. To the post of.
Any objection to item 37? Right, on the prayer for adjournment made on behalf of Mr. K. Chaudhary. Learned counsel for the respondent number. This is the matter. After 2 weeks.
Next week,
This is the matter in the next week.
much obliged.
May I please your lordship? My lord, item number 52, supplementary list, my lord.
Supplement.
We have taken steps upon the respondent, first steps upon the respondent number 7, my lord, day before yesterday, my lord. It may be taken after 4 weeks.
No, you wait. You wait.
I have some problem.
You may have some problem. You wait.
That is why, my lord, I am not suffering. I am not feeling well, my lord. Today, that is the reason, my lord.
Hmm?
My lord, your lordship may verify, my lord, David.
No, there's nothing here. There's nothing. This is a disputed question of fact with regard to whether you are an outsider or not. You go to civil court. I'm dismissing your case. Heard, Mr. H.M.R. Chaudhary, learned counsel for the petitioner.
Yeah, my lord.
Huh? No, I've heard you. I know your case. There's nothing here. You're an outsider. So there's a disputed question of fact.
Only for the day, my lord.
This is a disputed question of fact. What is that?
I understand, only for the day, my lord. I have.
Okay, right. On the prayer for adjournment made by Mr. H.M.R. Chaudhary. This is the matter. Tomorrow.
Yes, sir.
This- Today you said no, this is the matter tomorrow. Full stop. There, as part heard.
May I please, your lordship. Lordship, I beg to mention item number 16 and 45, lordship. The engaged counsel, Mr. S.K. Mehdi is in treatment, lordship. Kindly adjourn the matters. 16 and 45.
Who's for the other side? Have you spoken to the other side?
Lordship, we have taken consent.
Okay, right. What is your name?
Why Bolbhuya?
Huh?
Why Bolbhuya?
Appearing on behalf of Mr. S.K. Mehdi, CGC, submits that. He has taken the consent of the other side. And the matter may be adjourned for
Lordship, a week, lordship.
a week. This is the matter after it.
No pledge.
16 and 45.
I wish to mention listing of the case, my lord. This is transfer method, my lord. There is an instruction due to paucity of time that was not, my lord, given. So 30th is the date where a clause will be vacant. The petitioner has
30?
30 November, September is the date where a post may be taken in Guwahati, my lord, and instruction is there. So it may be listed in Friday, my lord, transfer method, and petitioner is donated the kidney and leg fracture still.
What is the matter about?
Transfer, my lord, transfer to Silchar. She wants at the Guwahati, this lady who is
She
donated.
wants to be transferred to Guwahati.
Yes, there is instruction also with them, but because a post will be taken, my lord, if case is listed before that, then there will be. Friday, my lord, it may be given.
30th is a long way off. Monday. No, wait, the 30th is today's. Oh, next Monday. Okay, Monday.
The instruction is
Monday.
there.
Monday.
May it please your lordship, I beg to mention item 21, lordship, this petition has become infractious. We've
Okay,
already been promoted, lordship.
okay, right. Miss, your name,
LP Choppy,
please write it down. Miss so-and-so appearing on behalf of
and this was.
Mr. M. Biswas, learned counsel for the petitioner, submits that the matter has become infructuous. And accordingly, the petitioner does not want to press this matter any longer. Correct? Yes. Who appears for the other side? Forest? SC Forest, no one. Right. In view of the submission made by so-and-so, the writ petition is dismissed as not pressed.
Highly obliged, lordship. The concern of the other side, I beg to mention, I think 50 of the daily list, lordship.
50.
50, your lordship. I'm appearing in this matter on behalf of Mr. Giras. He is in Azure today, your lordship. If it is not inconvenient for your lordships, can it be in the first week of October?
Yes, Mr. CC. Any item 50, they want adjournment. On the prayer for adjournment made on behalf of Mr. D. Das, Senior Counsel, which is not objected to by Mr. S.S. Roy, CGC. This is the matter in the first week of October.
Your lordship, the date may kindly be given.
What is the hurry?
Lordship, this matter basically pertains to dismissal from service, your lordship.
How does it matter? Matter first. How does it matter? List the matter on 9/10.
Thank you.
Item number 1, lordship, they have made a prayer for declaration of the results conducted for according to lordship, but there was some anomalies were there, lordship, accordingly, an inquiry was conducted, and after the inquiry it was found that the anomalies were there, lordship, accordingly, that government has decided to cancel the entire examination and conduct them afresh, lordship. This is the instruction we have received.
Now you have to challenge that. So end of the matter. Miss
G. Swami.
heard Miss G. Swami, learned counsel for the petitioner, who submits that though the petitioners have participated in the written examination as well as the computer test for recruitment to various posts under the Directorate of Library Science, Assam, the respondent authorities have not published the result of the selection process. Next para. Mr. H. Sharma,
Lordship.
learned additional senior government advocate, has submitted a letter dated 19/9/2023, issued by the Secretary to the Government of Assam from a Cultural Affairs Department, which is to the effect that as per the inquiry report, as per the inquiry made, the government has decided to cancel the entire examination and conduct them afresh. Full stop. He submits that the same has been done due to there being anomalies found in the recruitment process?
Lordship.
Mr. In the letter dated 19/9/23 is made a part of the record and marked as annexure X in view of the above letter dated 19/9/2023. The writ petition is closed as infructuous.
Lordship. Much open.
Annexure X. Huh?
May I please your lordship? Lordship,
Yes.
with the consent of other side, my lord, today my senior has some personal difficulty, my lord.
What difficulty does your senior have?
My lord, he has instructed me to pass over the matter only for a day, my lord. Matter maybe come out next week.
Why?
My lord, my senior has instructed me, he has some.
Mr. Council, there is a manner in which adjournments have to be made. There are notifications issued by by this court that when you want an adjournment to be made, you have got to submit a written application 1 day earlier. Now, what is your case in this writ petition?
My lord, in this case, my lord, petitioner was appointed as a my lord, grade 4 employee, my lord, with effect from 1/11/1992.
Grade 4 employee on 1/11/1992.
My lord. Hereafter, my lord, his service has been regularized with effect.
Now
from-
okay, 1992.
My lord.
Okay, then
Hereafter, my lord, his service has been regularized, my lord, with effect from 17/12/2005. Page 15,
regularized with effect from
17/12/2005,
17/12/2005
my lord.
on the basis of an order dated
Order dated, my lord, annexure 15, my lord,
page,
page 15, my lord. Annexure 2, my lord, page 15.
yes, but order dated
Order dated 17/10/2005,
17/10.
2005, my lord.
So what is your prayer?
My lord, as per my lord, government scheme, my lord, petitioner is entitled for financial aberration, my lord, that is MSCP scheme, my lord, page 23, my lord. Where there is, my lord, no scope of promotion, my lord. He has the right to entitle, my lord, for MSCP scheme, my lord, that is, my lord, page 23, my lord. Let me kindly peruse. Page
Yes,
23, my lord,
Yes.
Roman 3. The scheme will also cover isolated posts where there is, my lord, no scope for promotion, my lord. 10 years, 20 years, and 30 years, my lord. As my lord, petitioner has completed 10 years of his service, my lord, in the same post. So, my lord, as per my respectful submission before your lordship, my lord, he is entitled for financial
tell me one thing, when was the petitioner born?
petitioner. I don't know.
You don't know. In 1992, you were appointed, correct?
As a master role,
So, and in 1992, you have to be 18 years old.
my lord,
Now you come to your affidavit.
43.
How old are you?
43 years,
As on 31st July 2023.
my lord.
That means you were born on which year?
Calculate, my lord.
Now it's 2023. So you throw away 23 years, it'll be 2000. That means in 2000 you were 20 years.
Right.
That means you were born in 1980.
My lord.
If you were born in 1980, how could you have been appointed as a master roll worker when you were 12 years old?
Senior have to appear, my lord. That's all.
It's not a question of senior, it's a question of, this you have said on oath. This is on oath, this affidavit is on oath.
Definitely.
And then we'll listen tomorrow, we'll see, heard, Mr. What is the name?
S.A.B. Kabir, my lord.
Huh?
S.A.B. Kabir. my lord.
S.A.B. Kabir, who submits that the petitioner was appointed as a muster roll worker in the year 1992. No, on 1/11/1992. On 1/11/1992. And he was regularized by order dated 17/10/2005 with effect from 22/7/2005. The petitioner prays that he should be promoted to a grade 3 post, or in the alternative, to be granted financial upgradation as per the modified assured career progression scheme dated 6/7/2007. So stop. Next paragraph. On perusing the affidavit filed by the petitioner, it is seen that his age is 43 years as on 31/7/2023. Full stop. As such, the petitioner would have been born in the year 1980, in which case he was appointed as a muster roll worker when he was 12 years old. Full stop. This anomaly would have to be explained by the petitioner. List the matter tomorrow on the prayer of the
Yes, sir. Can
petitioner's
it be, my
cause.
lord, Monday, my lord.
Tomorrow,
Friday, my lord, Friday.
tomorrow, you said tomorrow.
Obliged.
You don't?
May it please your lordship. We have filed one additional affidavit, my lord, in this case, my lord. At the time of filing of this writ petition, my lord, we did not have those documents, my lord. That's why I could not annex in this writ petition, my lord. The matter pertains to, my lord, recruitment of grade 4 post, my lord, in the establishment of the presiding officer labor for Dibrugarh, my lord. Kindly, page 32, my lord, advertisement, my lord. As per this advertisement, my lord, there are 4 numbers of posts, my lord. These are all grade 4 posts. And the petitioner applied for 3 numbers of posts, my lord, by means of 3 separate applications, my lord. I applied for post P1 to PO, P1 to register and night secretary, my lord. 3 numbers of posts and 3 separate applications I had submitted, my lord. Interview was taken place on 14/7/2023 once. Selection board took only 1 interview, my lord. And mark assigned to other posts also, my lord. But the question is, my lord, here, they cannot hold interview, my lord. Right? As per, there is a 1 document, my lord, we have received after filing of this. Kindly peruse, my lord, additional affidavit, my lord, we have filed. As per this document, my lord, page, my lord, page 67 in additional affidavit. In additional affidavit, my lord. Page 67. As per this instruction, my lord, discontinuance of interview in recruitment of junior level post, my lord. As per this instruction, my lord, there is a direction, my lord, the system of holding interviews for recruitment of such grade 3 and grade 4 posts where personality assessment, not an absolute recruitment, will be discontinued with limited effect, my lord.
This has got no force in law.
Next page, my lord, page 68, my lord, kindly see, my lord. Annexure 2. So far as the, my lord, recruitment process as regards, my lord, grade 4 post is concerned, my lord. Interview is not required, my lord. But in my case, my lord, they took interview, my lord. That is the, my lord, case, my lord.
So that is not your case in the pleadings. Your case is that you applied for 3 posts
Yes, my lord.
and instead of having 3 interviews, there was only 1 interview.
Yes.
So what is wrong? You cannot blow hot and cold, Mr. Counsel.
At
What is
the time
wrong?
of filing of this, my lord, writ petition, that document we did not have.
How
my
does it
lord.
matter? And then how are they going to select? What is wrong? How does it prejudice you? They want to get the best. How does it prejudice you? Just because the Prime Minister says something, it does not become the
This
law.
is a minor. So far as the page 68 is concerned, my lord, it's instruction, my lord, government instruction, my lord. So far as the recruitment of
It has got no force in law, this one.
year 3 and 4 posts is concerned, my lord, they cannot hold interview, my lord. At least when a notice may go, my lord.
Why? Why should notice go? Yes, tell me. What?
Notice the code of labor program. Otherwise, I'm only appearing for the LR and the Ministry of Department of Labor.
Have you read the petition?
Yes, Lordship, because thing is that his application is for the post of peon and he can apply peon and other Lordship, secretary and body. And Lordship, his contention is that there ought to be, but in one process, Lordship. That
Did you hear what he was saying? Were you listening to what he was saying?
it was as per his additional affidavit, Lordship. That notification, Lordship.
What notification?
Page 68, my lord. It's the instruction, my lord, clear instruction.
This instruction, Lordship. That announced that the process of holding interview for direct recruitment to junior level post where personality assessment is not an absolute necessary requirement shall be discontinued. This part, Lordship. And your honorable senior director of the system of holding interview for recruitment of such getting where personality assessment is not an absolute requirement will be discontinued with immediate effect. So in regard to this, Lordship, let's let the labor court reply, Lordship, whether
Where are the marks on the base? How many persons took part in the interview?
three.
Three. What are the marks given? What are the marks secured by the candidate?
Total 230 candidates are appeared, my lord.
Now you tell me, on the base, how are they going to select candidates if there's no interview? Was there any written test?
No, there is no written.
There is no written test, so no interview is also required according to you.
Yes,
Then it will be as per pick and choose face. If you are handsome, you'll get 30 marks. If you are not very handsome, you'll get 25. And the person who's bald, he'll get maybe 5 marks only.
No,
How are you going to select?
no, my lord. As per this
You
instruction,
tell us.
first thing is that as per this instruction, they cannot hold interview.
Then how are they going to
But they
select?
took interview, one
No,
interview-
you just tell us one thing. You just tell this court one thing. According to you, how should selection be made?
so far, this instruction is.
If
concerned,
no written,
written
if there is no
Test is
written,
required, my
Huh?
lord. Test is required as per this instruction, my lord.
which is instruction?
I have annexed in.
Is this
Additional
what is your prayer in the writ petition? Let us see. What have you stated as to how the selection should be made in your writ petition?
Paragraph 10, my lord, in my writ petition, my lord. I have applied for 3 numbers of posts by means of 3 application, my lord, but they took 1 interview, my lord. And assigned, my lord, marks to other posts also, my lord. That is one aspect, my lord. At the time of filing this. writ
Look,
petition-
your cases, there is no requirement of having any written test. There is no requirement of having any interview, correct?
Right, my lord.
That's all. So then how are they going to select a candidate?
Written test is required, my lord. But they
Where
took-
have you said in your writ petition that written test is required?
that is, my lord, I have stated in this additional affidavit, my lord. At the time of filing of this writ petition.
Where
my lord,
does it say that written test is required as per the rules?
That has to be here, my lord.
Huh?
Only submission is that, my lord. They have ignored this notification, my lord.
You just, yes, you just give me the marks, how much they have secured, that's all. We told this writ petition.
Marks we have, my lord, paragraph 10, my lord.
Then we close it. What is there?
No, my submission as to why they have ignored this instruction, my lord.
Huh?
As to why the selection board ignored this instruction, my lord, which has been already issued in 2016, my lord. And it specifically stated that so far as the grade 4 post is concerned, interview is not required, my lord.
Will be discontinued because
What is the rule to be followed? What is the rule to be followed for appointment to these posts, according to you?
My submission is that, my lord, if I applied for 3 numbers of posts by means of 3 separate application, but they took 1 interview, how they can assign marks other posts also, my lord?
But now your submission is they cannot take interview also.
Because at the time of filing of this writ petition. we
So
did
they
not have
cannot
that
even take interview.
lordship.
Right now, your submission now as on today is that they cannot even take interview.
Lordship.
So now, so they can give any mark that they want if there's no interview.
No, written test is required, my lord.
Where does it say written test required? Show me.
My lord, page 68, my lord. Additional affidavit, my lord.
point number 1 today.
Yes.
I have-
Read it.
May I read, my lord? I
Yes.
am directed to say that some of the departments have referred the matter regarding to discontinue the interview in terms of the government decision communicated by letter cited above under reference. Some of the appointing authorities have made advertisements entirely specifying the manner of recruitment process prior to the issue of COP notification so and so dated 25/5/2016, and the conducted test for interview is yet to be held pursuant to the terms of the advertisement. Conducted test.
You see, some have conducted
It
tests.
does- it means, my lord, so far as the grade 3 and 4 course is concerned,
No case. Some have conducted tests. Doesn't mean that everyone has to conduct written test.
but it is clearly stated here in that interview is not required, my lord. So far as the grade 3 and 4 course is concerned, it is very blatant, my lord, at page 68. My simple case is that but they have ignored this notification, my lord.
This is not your case in your earlier part. You see your
Yes, my lord,
your
that
writ
is- that is
petition
true.
and your
because-
additional affidavit
Yes, yes, yes.
is at variance with each other. It is not a
At the time of
consolidated.
filing of this month that we did not have this instruction or notification order, my lord. That's why some difference has blatant in the writ petition, my lord. But fact is that, my lord, as per this notification,
Right, list the matter on Monday.
Interview conduct.
List the matter on Monday. We'll see on Monday.
lordship.
I'll just be ready on that day.
May I please, Lordship?
Yes, what is your case?
Lordship, this is the second writ petition, Lordship. I have challenges appointment, Lordship. I have lately get appointment letter, Lordship.
Huh?
Second writ petition, Lordship.
So
I have get lately appointment letter, Lordship.
you have got the appointment
Yes,
order.
yes.
So what do you want?
Lately, Lordship.
So what do you want?
Lordship, second writ petition, Lordship. First writ petition, Lordship, 4619, Lordship. I want to, Lordship, issue notice to respondent number, Lordship,
Why?
and take up with
writ petition nong
Why should this writ petition be allowed?
lordship. Lordship, I eligible lordship.
You're eligible for what?
Anganwadi helper lordship. To promotion Anganwadi worker lordship.
Lordship, actually, the petitioner's case is that she wanted a promotion
Hmm.
from helper to worker, Lordship,
Ah,
as per to 2013 notification. But someone has been transferred and given that post, Lordship.
okay.
Thereafter, she was aggrieved and filed an writ petition before this honorable court. When the honorable court passed a direction that authority to consider her representation and all this. Lordship may now kindly peruse page 16, Lordship, Annexure 2. Where
Yes.
the director has taken up the matter and hearing was given, Lordship,
Hmm.
and the relevant page is page 17.
Yes,
The last paragraph, Lordship,
yes.
whereas the CDPO Rupsi in her report received by letter number so and so has stated that though the eligibility for the post of Anganwadi worker is mentioned as class 9 pass, as per government notification 4/3/2013, Srimati Jahanara Ahmed petitioner submitted an application with class 8 pass certificate during selection and office received her class 9 pass certificate only on so and so 10/8/2017. The petitioner also submitted two different certificates dated 26/7/2001 issued by the principal Peradhara Higher Secondary School, Ladukuchi, Nalbari, and another certificate dated 4/2/2002 issued by the headmaster Paschim Kajeswar High School, Ladukuchi, Nalbari. But on due verification by the CDPO Rupsi ICDS project regarding class 9 pass certificate issued by the headmaster Paschim Kajeswar High School dated 4/2/2002 against Jahanara Begum, it has been found that the concerned headmaster of Paschim Kajeswar High School denied of issuing any such certificate. The same can be evident from the declaration submitted by Jinnat Ali Ahmed, the former headmaster and issuing authority of class 9 pass certificate of Jahanara Ahmed, as well as the present headmaster of Paschim Kajeswar High School. Considering the above facts and materials and record, I am inclined to arrive at a decision in the matter that the petitioner, Srimati Jahanara Ahmed, lacks the requisite eligibility qualification for the post of Anganwadi worker as per notification dated 4/3/2013. So this has been considered, Lordship, as per direction passed by this honorable court in the earlier writ petition, Lordship. So
She doesn't have the qualification.
qualification.
No, but
Lordship.
what about this other one? The petitioner also submitted two different certificates dated
Yes, Lordship, an
26.
enquiry.
What about
Lordship.
this principal Peradhara Higher Secondary School? This one,
Yes, Lordship. In-
nothing has been stated about this.
Yes, Lordship. She submitted two certificates, one 8 pass and one 9 pass.
Acha, this Peradhara, this one is class 8
Yes,
pass.
Lord, submitted an application with 8 pass certificate during selection and office received her class 9 certificate only on 10/8/2017. The petitioner also certificate two different certificate. So how can it be, Lordship?
Okay, so this certificate issued by the Peradhara Higher Secondary School
Yes, Lordship.
is a class 8 certificate.
Yes, Lordship.
Are you sure?
This thing is not mentioned here,
Then
Lordship.
that
Class
is
8
what-
pass certificate during her expansion, but 2017.
Yes,
Yes,
where-
sir.
where did you, when,
Details Lordship, writ petition now, first writ petition now 4619 Lordship, 2022 Lordship. I want to Lordship take up this petition Lordship, issue notice Lordship.
no. You tell me straight away now. Where did you pass your class 8?
Class 8 Lordship, Peradhara High Secondary Lordship.
Where? Peradhara.
Peradhara, yes, Lordship.
And where did you pass your class 9?
Class 9, no Lordship, class 8 pass.
Okay, you are
Class
you
8
are
pass,
only class
Lordship.
8 pass. You're not class 9 pass.
Lordship, next Lordship, Paschim Kajeswar Lordship, admission on class
9.
9 Lordship. Lordship.
Did you pass class 9?
No Lordship.
You did not pass
Next,
that.
next financial problem, Lordship, next marriage, after marriage, some year marriage, next San Mama High School Lordship. Details Lordship, writ petition now, first Lordship, details submit, I have submit Lordship.
San Mama High School. When
Yes,
did you
Lordship.
pass?
2000, Lordship. 44 days.
No, you look.
In other.
No, you tell me.
Lordship,
When did you pass?
10 fail, Lordship,
10 fail,
9 pass, Lordship.
9 pass. When did you pass last night?
2017,
2007.
Lordship. 2018, I appeared, final examination, 10.
I'm not about 10, I'm about class 9. Do
Yes,
you
sir.
understand what I'm
17,
asking?
17, Lordship.
17 you
Yes,
passed.
Lordship.
And this matter pertains to,
2016 Lordship, the
Appointment 2022. 2022 appointment.
2016.
so he said that he passed last night, she passed last night in 2017. Then in that case, it appears that she's got a case. Let us, right. The,
And Lordship, during selection, she produced a class 8 pass only. During selection,
no,
because.
but then you see, when you,
High school.
please come to page 17,
Lordship,
the second paragraph on
yes,
top.
Lordship.
It says TDPO Rupshi
Yes,
issued advertisement dated 21/12/17.
yes, Lordship.
Now it was an advertisement issued in December 17. Now you come to the same page, the
Lordship,
last
10
paragraph,
2017.
yes,
Lordship.
on August 17.
Yes,
So
Lordship.
that is prior to the advertisement.
Prior to advertisement.
So petitioner got a point,
Lordship.
right? Petitioner claims appointment, promotion to the post of Anganwadi worker. Full stop. Though the order dated 27/1/2022, 2020, issued by the Director Social Welfare, states that the office of the CDPO, Rupshi, had received the petitioner's class 9 pass certificate only on 10/8/2017, comma. The said order also reflects the fact that the CDPO Rupshi had issued the advertisement dated 21/12/2017, comma, meaning thereby that the petitioner had the requisite qualification at the time the advertisement was issued. Full stop. As the petitioner also submits that an earlier writ petition, comma, that is WPC number
4619/2022, Lordship.
4619/22 is pending before this court. Please this matter along with
Lordship,
4619/22. Well,
issue notice.
what?
Issue notice, Lordship, yes, sir.
Wait, let me see both. On Monday,
Thank you.
let it come together. We'll see.
Thank you.
Yes, what is your case?
My lord, the matter relates to denial of promotion of the petitioner in the post of senior assistant. My lord, his junior has been given the promotion in the post of senior assistant, but he has not been given.
Why?
My lord, the reason best known to them.
When did you join?
My lord, I joined on 3/8/1990. And my.
Wrongly
junior-
shown to have joined in 91. That's your case.
Wrongly, my lord, they have shown, and I have given a representation.
So
to
you-
candidate
you have-
also.
So what is to be done?
My lord, let them give reply, my lord. At this stage, your lordship will issue notice.
Yeah, promotion to what post?
Senior assistant.
Right. Heard Mr. L. Datta, learned senior counsel, who submits that the petitioner joined the post of LDA on 3/8/1990, though the respondents have wrongly shown the date of joining of the said post by the petitioner as 30/05/91. He submits that while the junior of the petitioner has been promoted to the post of
Senior assistant.
senior assistant, comma, the petitioner has not been considered for the said promotion. Issue notice returnable in 4 weeks. Ms. M. Bhattacharjee accept notice on behalf of,
Only for two lots.
that's point number 2. While Mr. A. Fukan accept notice on behalf of point number 1. Petitioner takes steps for service of notice upon the point number 3 by a registered post with AD within 3 days. This is a matter of the court.
Much.
My lord, these petitioners, my lord, following the recruitment process, they were, my lord, appointed. Page 20, your lordship will see,
Page?
20, my lord, 20.
Yes.
This, each of the petitioners were issued appointment letter for the post of peon. And accordingly, they were directed, my lord, to join in their service on 8/3/2021. Now, thereafter subsequently, my lord, after the,
Join within what period?
within, my lord, on 8/3, within a week, my lord,
Where does it say?
it's mentioned, my lord. Now subsequently,
No, where does it say that? You have to join within a week.
my lord, your lordship will find at page 29. Subsequently, my lord, when we went for joining, my lord, in the interim period,
Where does it say that you have to join within a week?
please refer to a letter that so and so on the caption subject where you are instructed to report to branch of Dibrugarh on 8/3/20.
I have got 2/3/21. Where does it say in 2/3/21 that you have to join by 8/3/2021?
My lord, after appointment of this letter, my lord, in between, my lord, 5/3, page 29, I was asked to join within 8/3, but they have referred.
Okay. In page 21, para 7.
Yes, sorry. Yes, man, I'm sorry, man. Now, after this, my lord, what happened at page 29?
So you have not been allowed to join,
Yes,
basically. Yes,
I'll have to take instructions.
okay, right. Heard, Mr.
B. Borwa.
B. Barwa, learned counsel for the petitioner who submits that pursuant to a selection process, comma, the petitioner was appointed as peon
Yes,
in BO in the branch office of the PNB at Dibrugarh University campus. Provide letter dated 2/3/2021. So, in terms of para 7 of the said letter, he was to join his post on 8/3/2021. Full stop. However, the petitioner has not been allowed to join his post even till today. Full stop. Mr.
A. Ganguly
A. Ganguly,
for 1 and 2.
appearing for the respondents number 1 and 2. Prays for time to obtain instructions. Accordingly, leave this matter in the next week.
It's October 1st.
Accordingly, leave this matter on 3/10.
The RNC votes with party which is popular.
my lord, responded, yes, yes.
Oh,
That notice may go,
Labor Commission.
notice
Why?
may,
why Labour Commissioner? Why is Labour Commissioner party?
my lord, he has issued a letter, my lord. There is a reference at page 39 that he has asked the bank authorities.
Oh, so you have already gone before the Labour Commissioner.
We are not there, my lord. There is apparently some other labor dispute pending between the employees union, my lord, of the erstwhile UBI and the,
You obtain instructions.
I'll take it.
Obliged. May I please, your lordship. Lordship petitioner before your lordship, thank for a limited prayer, lordship. Lordship petitioner, lordship was recommended by the lordship Director Employment and Crafts Training, lordship.
Show me the order.
Lordship kindly see page 22. An excerpt for lordship. Petitioner name appears at the serial number 6.
Just a minute. Page 22.
22, lordship.
For a grade 4 post.
Lordship.
Then what happened?
Then the lordship petitioner went to the office of the Heirloom Textile Director Office, lordship. For the joining, then the lordship, the director says that since one post is lying vacant in that office. But in the
Mr. Council, this is of 2009
lordship,
and you're coming here to 2023 after 14 years.
lordship,
It's also of 2013 lordship.
Huh?
lordship.
The what order he is lordship.
Okay, then,
Lordship is some of the lordship, some of a similar situated person had approached before this honorable court, lordship, lordship kindly.
no,
say-
then what happened? 2009,
Lordship,
then what happened? After this recommendation, what happened?
then the lordship petitioner approached the director crafts and training center, that I was sent back because only one post is lying vacant in the office of the director of Heirloom Textile. Then the lordship, in the meantime, the lordship was some of similar situated person approached this honorable court, praying.
One post lying vacant, where does it say one post lying vacant? Which letter?
Lordship, it was the. Lordship, kindly say next year 5.
Page.
Yes, lordship. Page 25, lordship.
Hmm?
Petitioner was intimated, lordship. Page 25, annexure 5. Petitioner lordship submitted an RTI application, and through which petitioner was informed that some of the similar situated.
Where is that RTI
Lordship,
application?
kindly see Page 5.
Page
Annexure
5,
Page 25, annexure 5.
page 25 and it's.
Yes, answer. Relevant portion is page 26, lordship.
Yeah. Yes, so someone filed a petition,
Lordship.
WPC number,
5007/2009.
yes, then.
Then
what-
the
what is-
lordship,
Where is the order passed in the case?
then the lordship,
Were you a writ petitioner in this case? No.
no, lordship, because I did not aware about the petition. Lordship, kindly see page 34, annexure 10. And judgment starts from page 77, lordship. Order dated 9/12/2013, lordship.
These are different. These are 387420, then
Yes, lordship. A
109.
base of the writ petition was filed to lordship.
The
Huh?
order is of dated 9/12/2013 lordship.
okay, in this repetition, you are not there.
Lordship.
No lordship. He was a friendship.
Fence sitter. Disposed of on 9, page 77, page 9/12/2013.
So kindly see page 78. Which has been reflected.
78,
The lordship,
yes,
paragraph 2, lordship.
yes.
I'm reading, lordship. For
Yes.
for the sake of convenience, the cases are broadly divided into 3 groups. Group A dealing with a selection and appointment to grade 4 posts in the state service. Group B relating to selection and appointment to grade 3 posts of state service and for appointment to such a post. And the group C comprising of only one cases where challenge to the selection and appointment in grade 3 has been made on the ground of non-compliance of statutory reservation for women category. And my case covers, lordship, group A, lordship. Until paragraph
This is for appointment to grade 4 posts.
4 post, lordship.
On what basis?
Lordship, by virtue of a lordship advertisement made in the year 2017, that is lordship 18/5/2007.
Advertisement dated?
advertisement dated 18/5/2007, Lordship, which has been reflected in the judgment also, Lordship.
So thereafter, so as per para 29,
Yes, Lordship.
Lordship.
the list of the remaining rate for selected candidates was to be placed
Yes.
before the chief secretary, who shall ensure that the case of the state, placed before the state cabinet for necessary decision. And what is the decision of the state
And
cabinet?
Lordship, kindly see page.
Huh?
Within a period of 4 months. Lordship.
Then what happened?
Lordship.
Then what happened?
Then the Lordship kindly see last observation made in paragraph 54, page 116, Lordship.
Yes,
Melody. In view of the above, the conclusion may be summarized as under. Number one, Roman 1, Group A cases are allowed as per direction contained in paragraph 29 of the judgment. Roman 2, Group B and Group C cases are dismissed. And Roman 3, all interim orders are vacated. And since my lord, my case is covered under the petition number 5007, Lordship, and my lord, the petitioner submitted a comprehensive representation, Lordship, that is page 118, Lordship, and Annexure 11, Lordship.
In
Lordship, my
2023.
limited period is that, my lord, this representation may be disposed of, my lord. To direct the Lordship authority concerned to dispose of my representation, Lordship.
you are not a party in those petitions, Mr. Council.
And this representation is of 2023 Lordship, now only. And 29.29 clearly says that it has to be done within 4 months, 2013. After 10 years, Lordship.
No. You have
And not the party Lordship also.
not a party anyway.
Lordship.
What has happened, but did something happen in terms of the order?
Lordship, that's, I'm not aware of Lordship, but Lordship, that is of 2013, now it's 23. He was not a party to that petition, Lordship. And now he has come. For 10 years, he was only sitting.
My lord, the petition is totally, my lord, unaware about the filing of,
Huh?
about the judgment, Lordship, for disposal this petition, Lordship. Since the petitioner is, my lord, the daily wage earner, Lordship. He moves hither and
But he
thither,
was not a
Lordship, for
party
his
to that
livelihood.
petition, Lordship. He was just a fenciter, Lordship.
My lord, this is the question of the fundamental rights. In fundamental rights, there is no question of any delay, Lordship.
Your rights can be defeated by delay. There's enough Supreme Court judgments. When you sleep over your rights, you lose your rights. You cannot be a Rip Van Winkle.
My lord, the petitioner is in
Son,
Lordship.
so one fine day you suddenly get up. After that also, your recommendation was done in the year 2009. And you have come to this court in 2023,
My lord.
after 14 years.
Lordship, petitioner moves hither and thither, Lordship, only for his
You
livelihood.
carry on moving. You
Lordship.
move for 14 years, move for another 14 years.
Lordship, when he aware about this, my lord, judgment, he rushed to the High Court and obtained this judgment and submitted the representation and thereafter,
RTI
Lordship,
is
the
a-
petitioner approached
His
the Sonal
RTI
Court.
is also of 2011, Lordship.
RTI,
Lordship.
page,
Page 25, Lordship. Annexure 5.
28 October 2011.
you had the good sense to file a RTI. But
My lord.
so you were in the knowledge of.
My lord,
Okay,
there-
right, heard Mr. Yes, Salih, learned counsel for the petitioner who submits that the petitioner applied for appointment to a grade 4 post pursuant to an advertisement dated 18/5/2007 issued by the Director of Employment and Craftsman Training, Assam. Thereafter, the director issued letter dated 20/02 2009. To the Director of Handloom and Textile, Ambari, Guwahati. Informing him of the sending him a list of recommended candidates for appointment to grade 4 post, which included the petitioner. Next paragraph. As no appointments were being made, the petitioner submitted an RTI application on 20/10/2011 to the SPIO/Deputy Director of Employment, Director of Employment and Craftsman Training, Directorate of Employment and Craftsman Training, Assam. The reply to the RTI application was given when, in the same year, was given when is this given? On 20,
The next
Then-
page, Lordship,
Huh?
26, page number 26, Lordship.
Page 26, Lordship.
on which date?
26.
On
9,
26
2009.
9 2011. 26 9 2011. How can it be? Acha, RTI application is 26 9
Yes,
2011.
Lordship, where the 26,
Aye,
9,
and-
2011.
The reply is given on 20/10/2011. Stating that none of the recommended candidates had been appointed to grade 4 post. And one WPC 5007/2009 had been filed in the High Court. Next paragraph. The petitioner's counsel submits that a number of writ petitions were filed by similarly placed persons as the petitioner, challenging the inaction of the state government in not making appointments to various grade 3 and grade 4 posts despite being recommended by the selection committee. The various writ petitions filed by the other persons, the leading case being WPC 3874/2009, was disposed of by order dated 9/12/2030. Wherein this court directed that in cases involving appointment to grade 4 posts, the chief secretary to the government of Assam was to ensure that the cases of the recommended candidates should be placed before the state cabinet for its decision. And the state cabinet would consider the matter and take an appropriate decision. The entire exercise was to be carried out within a period of 4 months from the date of receipt of a copy of the order dated 9/12/2013, 9/12/2013, passed in WPC number. Passed in the batch of cases, the leading case being WPC number 3874/2009. Next para. The order of the High Court was thereafter. No, the petitions council submits that though the petitioner was not a party in any of the cases that had been disposed of by the High Court, while the order dated
9/12/2013.
9/12/2013, the petitioner submitted a representation dated 30/8/2023 to the Chief Secretary, Assam. To take a decision as to whether to take a decision to appoint him to a grade 4 post in terms of the order dated 9/12/2013, passed in the batch of writ petitions involving WPC number 3874/2009. Your plain instructions, madam, as to what was the decision. Okay. Because you see, once a decision is, if decision has to be taken.
Since 2013.
No, but then if he's not there in the decision making process, if his name is left out, then it's okay. But at least whether decision has been taken or not. He was not a party.
This not a party. And the decision is also of 2013. Now it's 2023. All the appointments have been made, maybe, within the term of four months.
Okay. No, I just want to know if a decision has already been taken in those cases.
That I can take.
If a decision has been taken in those cases, and if the petitioner's case was not considered, there's no harm, there's no problem. Okay, anyway, right, Miss
8 Talukdar.
A. Talukdar, the learned counsel for the
1 and 2.
respondents number 1 and 2. Submits that the present writ petition is hit by delay in laches. As the petitioner has not made any challenge no, as much as the petitioner has not approached this court at any time claiming appointment on the basis of the recommendation made by letter dated 20/02/2009. He further submits that the petitioner not being a party to any of the writ petitions, the leading case being WPC 3874/2009, which was disposed of on 9/12/2013. The petitioner cannot be allowed to write piggyback on the orders obtained by other person. On considering the fact. She has got a point also.
Lordship. My lord, the
Lordship, in
limited period is
2011
that
also,
lordship since
he
the
could be a
petition
party
submitted
to
the
this
representation, my
matters,
lord, the government.
when he
My
got
lord,
the
maybe
information
directed to take the
by the
decision on
RTI
the lordship
that
representation,
this
my lord.
process is going on, then also he could have been applied lordship or.
My lord, so whenever the
for
petitioner
silent
knows about
petition,
the final
He was
judgment of
sitting on the
the.
lordship.
You just get the, whether decision must have been taken.
Lordship, in 2013, lordship,
Maybe. She does not know whether the government has taken any decision regarding this
he got the
judgment.
information in
She does
2011.
not know about
Then
that,
also he
lordship.
was sitting lordship.
I have heard the learned counsel for the parties.
My lord, the petitioner clearly state in paragraph 12 and 14, lordship.
All the process must be completed lordship. Now after 10 years, it will be difficult lordship.
Just find out whether the decision has been taken, so that only that. Because we'll list it on Friday.
Lordship.
List this matter on Friday to enable Ms. A. Talukdar to obtain instructions as to whether a decision has been taken, has already been taken on the basis of the and whether his name is
There in the
included
list.
in the, if his name is not included, then
Because
there's
he has not
nothing.
approached lordship. He must have not approached lordship after this 2013 matter, lordship.
Lord, the
Now
petitioner
it will
lordship
be very
clearly
difficult.
lordship stated in paragraph.
You have come after 14 years, Mr. Counsel. That is the
It is
point.
only that the
Lordship,
order
it is admitted
says
that the
that
lordship,
group
the
A
petitioner
lordship.
is the lordship, I am fairly stated and categorically stated in paragraph 12 and 14. That
Yes,
is the
lordship. If
petitioner is a daily wage earner,
the
lordship.
petitioner
She
is
is
not
having
in
a
group A lordship.
old age at a parent and a minor daughter. He
Okay,
has to go-
dismissed. I'll pass. Dismissed. Next.
You oblige lordship.
Oblige.
Yes, what is your case?
My lord, the petitioner lordship initially appointed in the year 1993, my lord. Consequently, see at page 11, my lord, first appointment, my lord.
Page?
Page 11, my lord, and lecture 1, my lord. Workstocks section.
Just give me this file. Miss case number. Just give me CR 521 of 1997. No, you have to take from the register. 521. 521 of 1997. I think that is the record required, correct?
My lord,
521 of 1997 is required.
yes, my lord.
521 of 1997. We'll take this matter at 2, huh?
My lord.
At 2.
May I please, lord. My lord, the petitioner before your lordship is a assistant security commissioner of railway protection force, my lord. He presently working at Maligaon, my lord. And what happened, my lord, while he was working at Delhi, my lord, that time inquiry was initiated against him. And after that, my lord, the inquiry report was submitted
Inquiry was initiated against him.
against him in connection with a viral audio clips.
Viral audio tape.
Viral audio. Thereafter, my lord, on 23/9/2022, the inquiry report was submitted.
When?
23/9/2022.
23/9/22.
Yes, my lord.
Inquiry report submitted.
After that, my lord, he was transferred on 14/2/2023 from Nizamuddin to Maligaon in a different journey. Thereafter, my lord, the Security Commissioner Delhi Division, my lord, is issuing letter asking me to give voice sample from Delhi, my lord.
So the inquiry officer is asking you to give voice sample.
Voice sample.
So you are what? You are objecting to that.
Yes, my lord, because I'm not under his control now. And it is a
Lordship, the inquiry is going on, Lordship. And he is transferred to.
Inquiry is not complete.
Not complete, Lordship. He has transferred from the.
inquiry report has been submitted.
It is not complete. So
I have
who is the
annexed it.
authority?
I have annexed it.
Page.
Page 19 annex 1.
Now there is one issue. Supposing our inquiry is completed, can it be reopened
My lord, what I would like to submit, my lord, there is
before a final decision is taken in an inquiry?
Yes,
Can the inquiry be reopened?
yes, my lord, that issue is also there.
Huh?
That issue is also the moreover, my lord, there is a notification issued by the railway board with regard to the exercise of disciplinary power in respect of railway servant transferred from one railway division to another. There it has been clearly stated. May I read the
Yes,
relevant?
where is it here?
My
Is
lord,
it here?
No, my lord. May I read the?
Is it part of your pleading?
No,
This is on the first day itself when you bring out the.
only today I have.
Only today you have got it. Then you file additional affidavit. Only today you got it. We do not know from where you have got that.
It is issued by the railway board. my lord. Here it has been clearly stated it is wrong.
To do what?
So may I read the relevant? Question?
You give me a copy also.
Yes. please. The second.
Where is your copy?
I.
Unreadable. On the prayer of the petitioner, list the matter after review. Next.
In the meantime, I will tell additional.
I am appearing on for all respondents.
Huh?
I am appearing for all respondents.
After review. On the prayer of the petitioner's counsel, list the matter after review.
I would like.
Wait for a Passover method, my senior is on break after some time. This is claiming retrospective seniority. Limited, no, it's limited prayer was to dispose of the representation because in earlier times also, once the petitioners get a disposal from this the honorable court regarding passing a reason order, either whether they are eligible for retrospective seniority or not. The work.
No, is there any quota rota rule available here? What is this? What is the issue here?
Now, the issue is, my lord, they were denied the promotion because regarding their degree from the AMISTP, my lord. The diploma degree from the.
Whether the degree is, whether the
That
degree
has
is,
been considered to be valid. They were promoted. Now the
the
effect of promotion.
degree has been stated to be valid by whom?
My lord, they have been promoted, my lord, based on. that.
Maybe, no,
Yes.
but subsequently, whether the degree is still valid or not.
My lord, we are not on the validity of the degree or not.
You might not be, this court is.
But what has happened is earlier in times, my lord, many similarly placed persons have come before this court. This court has granted that.
I don't issue notice.
Issuing a notice going up.
You see, one thing, you've got to, you see, maybe earlier, courts had maybe held that the degree to be valid. But subsequently, there are orders from the Supreme Court whether when those degrees are said to be invalid. So whether it comes
But
within
I
those,
don't come under those degrees, my lord. Mine is a professional diploma degree, my lord. Those are different, my lord. The Orissa lift irrigation doesn't come into play in my domain. And in fact, if I place before your lordship's own order, based on that, this person has already been promoted along with me. And now regarding retrospective seniority, I can show another example. After I have ordered from this honorable court, he has been granted the same seniority.
No, but then is this degree still valid? Or is? What does the Supreme Court say now with regard to these degrees?
Well,
This is a, this is a distance education thing?
no, this is not dispensation. Well, these are professional. This is a degree from a professional body. And it has been clarified in mechanical engineers judgment order. After this order, my lord, your lordship has directed the authorities to pass a reasoned order regarding his claim for promotion. And this petitioner, my lord, Jayanta Kumar Goswami, the order your lordship is holding right now, he has been promoted along with me. The promotion order I have also annexed, and I can show another example which I have annexed in the writ petition itself, my lord.
You are asking for promotion from which date?
From my lord, 16/9/2015, because on that particular day, similarly placed persons were promoted.
When were you promoted?
My lord, I have been promoted recently, my lord. On can you claim on 6/1/2020.
Their latches.
Well, let me place before your lordship one small example which I have annexed in the writ petition itself. On page 91. Page 91. Now, this particular gentleman at page 91, my lord Probin Talukdar, he was promoted. Then he again approaches this court, and this honorable court, by order dated 9/12/2022, my lord, passes an order directing the authorities to examine and dispose of the representation by reasoned order. Again, in the para 3, your lordship will see he has claimed retrospective seniority from 16/9/2015. That is the time when his colleagues were promoted who had the same qualification.
But
Pursuant to
you are
this, my lord-
promoted to the post of assistant engineer.
Yes,
By what? On the basis of a court order?
yes, my lord.
Where is the
That-
court order?
Yes, my lord. This is the court order 9/12/2022. Page 92, my lord. Page 90, 91 and 90.
That is Probin
Yes,
Talukdar.
that is Probin Talukdar.
No, I'm talking about you.
Yes, sir. Let me just finish the example, my lord. After this order, page 94, this Probin Talukdar has been
I'm not
promoted.
so fast, Mr. Counsel. I've got to read.
Right.
For you, you have read it 20 times, maybe. I have
Right, right.
come from it before me for the first time. Who are those persons who have been promoted ahead of you?
My lord,
They are from some reserve category.
no, my lord. My lord, That promotion order 16/9/2015, I placed my at page 41, my. This was,
You are promoted when?
I have been recently promoted on 6/1/2023. based on a court's order. That I,
Yeah, 6123.
based on a court's order.
Where is that court order?
That court order, your lordship will find at page 54, my. WPC 86 of 2016. And the judgment is of 16/6/2022. Same order, my lord, just to examine their claim and pass it on. I am petitioner number 2, my lord, Ashrafuddin Ahmed.
What was your prayer in this writ petition?
My lord, seeking promotion from the post of JE to AE.
With effect from the date your
No,
juniors
the
were promoted?
effect was not there.
Then how
The
can you
effect was
now,
not there.
that issue
Now-
is gone?
Yes, my lord. Now, since this Govind Talukdar fellow, my lord, after the passing of this honorable court's order, he has been given the retrospective seniority. I am simply seeking a disposal of my representation.
Then let
Because
him make
as of today, my lord,
Govind
they have-
Talukdar a party here, my lord.
no, I am giving him giving
Well,
an
he's
example, my
taking,
lord.
taking a rider from somebody else. He is promoted in 2023, whereas he is claiming his seniority from 15.
My lord,
No, I'm not on that. More than that,
Well, I'm not-
the issue is, if you had made a prayer in the earlier writ
Earlier
petition
it petition.
to be promoted with effect from the date your juniors were promoted, then you cannot now come with the same issue before this court.
my lord, if I may, my lord,
That you can go to that court,
my lord, if I may, my lord,
file a
I-
review.
that
You
instruct-
give me this, you get this, the WPC 86/2016, you get the file. Take it up at 2.
perhaps it might be there. Because
If it's there, then you file a review or you do something. That issue has gone, you file a appeal or something.
But my lord, what my understanding says, I am not claiming any positive direction.
No, may not be, but
I'm
then they
simply
are
claiming-
indirectly claiming.
My lord,
Now, once this goes, then you will, we cannot, you do whatever you want, but not through the court order. We will clarify it in the order, whatever has to be passed. Page, this is WPC 86/2016.
Perhaps on some other day, my lord, because
Huh?
it will take some time.
It will not take time, by 2 o'clock it will be here.
Okay.
Put this to the side. Item 11.
Lordship,
Yes, what is your case?
Lordship, I was participating in a selection process initiated by the staff selection commission, Lordship. And Lordship, the cutoff was declared. I got more than the cutoff.
What is the cutoff?
Lordship, I'm a scheduled caste category,
So
Lordship.
SC cutoff is how much?
SC
Page
cutoff,
52, Lordship.
page 52, Lordship.
For Assam
Six-
Rifle, it was 82.
Huh?
For Assam Rifle, it was 82.39710. For BSF, it was 64.
Okay, so different.
Different.
So you got the cutoff.
Yes, Lordship.
Then, so what is your
BSF and
case?
CRPF, I got the cutoff.
Then
Then my name was selected, Lordship. I was not selected.
you got this, you got the cutoff
Yes,
and you were selected,
Lordship. No, not selected.
not selected.
Yes, Lordship.
So what is wrong? How many posts are there?
Postal line vacant, Lordship.
How many posts are there, Mr. Council? How do you know posts are lying vacant when you don't even know how many posts are there?
Lordship, kindly be page 48, Lordship.
Page 48,
7.2, Lordship. Page 48,
page 48, yes,
7.2 mail.
7.2 mail.
Lordship, male in vacancies in respect to SC is 6,726.
Yes,
And Lordship, candidate selected is 668. The post are lying there. My case is Lordship, I got the more mark than the cutoff in respect of two cadre Lordship, but I was not selected.
but we will have to see how many persons above you have also not been, just because you get the cutoff. Doesn't mean that you automatically become, you get the post. Because there might be a number of persons who have also got the cutoff and who have got higher marks than. So that will have to be seen.
Notice, in other cases, notices were issued. Lordship. Details of the selection process of 27/10/2020.
2020,
2022.
27/10/2020.
Lordship.
So,
Notices were issued. Lordship.
no, so how much is your marks?
63.0566.
63.05, 64.6.
63 point
63.05, 646.
646. What is 646? 05646.
Yes.
Oh. So many.
Yes, so they have. Count
Lordship,
Lordship,
So now we will have to see how many persons are above you who have not been appointed.
For which which CF he has applied for also he has
Which one have you applied for?
I have applied for all of Lordship.
all.
All. Normally,
But
they have
he has
selected.
given A, B, C, D also.
Yes,
It has to be taken care of. Lordship.
So this is the thing that they will have to see. You see, they will have to calculate as to whether you can be accommodated.
Let them take instruction Lordship.
Notice maybe issued on other cases, notices were issued. We will file our affidavit.
But the notices, will issue notice, nothing will come out of it. You'll take 1 year's time.
Madam, maybe Lordship fixed after 1 week. Let them take.
1 week, nothing will happen. What do you think? This is a machine. They've got to go through volumes of records. Only for you, why should they do that? That is why I'm saying. They will take time. 1 year, at least minimum 1 year, so they'll take before anything comes to this court. So if we issue a direction that they should examine as to whether he can be accommodated depending upon his marks vis-a-vis other SC category candidates who have not been appointed, but who have also crossed the cutoff. That is one way. Otherwise, we can issue notice. That is not a problem. But for 1 year, so you'll have to wait. I think. I think that's the best way. What do you think? But then again, with contempt, will have to be filed on it.
That way,
That is
that was one.
that is again a problem. Huh?
Lordship.
See what you see what he's saying now. Basically, nothing will happen. That's what he's saying.
Lordship, let them carry the process and just inform me the results.
Within a
Whether my
specified time
case
period.
case was case.
You applied for all posts,
Yes, Lordship.
all the paramilitary forces you applied.
Yes, Lordship. On priority basis, normally Lordship, the candidates on priority basis, they give all the names. Like, I want to, priority number 1 is BSF, CRPF.
Correct. Heard, Mr.
Yes, to the Lordship.
S. Sutradhar, counsel for the petition who submits that in persons to the notice dated 27/10/22 issued by the Staff Selection Commission inviting online applications for filling up the posts of constables (GD) in the Central Armed Police Forces (CAPFS). The petitioner took part in the selection process held in the year 2022. Next para. The petitioner's case is that he belongs to the scheduled caste community. And he had secured the qualifying marks required. He had secured more marks than the cutoff marks required for a SC category candidate. Good, sir. The petitioner's counsel submits. Next para, the petitioner's counsel submits that the petitioner secured 63.05646 marks. However, the petitioner has not been appointed to any of the posts of constables bracket GD in the CAPFS. Next para. The petitioner's counsel has referred to
Page 48, Lordship.
para 7.2 of the letter dated 20/08/2023 issued by the Deputy Secretary bracket C dash I bracket close comma Staff Selection Commission, which shows that out of the 6726 vacant posts reserved for SC category, comma 6568 posts have been. No. 6568 candidates have been selected, comma thereby
158, Lordship.
leaving 158 posts. 158 vacant posts for SC category candidate. Next para. The learned counsel for the petition submits that this petition can be disposed of if a direction is issued to the respondents, comma, especially the respondent number. It will be
Response number
three. To verify the marks obtained by the petitioner and take a decision as to whether the petitioner can be accommodated in any of the remaining SC category posts after comparing his marks with other SC category candidates who had also secured more marks than the cutoff marks. Set SCT set for the SC category candidates. Next para. Mr. S.S. Roy, learned CDC, submits that he has got no objection to the prayer made by the petitioner's counsel. Next para. In view of the consent of the parties, comma, this the respondent number, the respondents, comma, especially the respondent number 3, is directed to verify the marks obtained by the petitioner and whether he belongs to the SC category. Full stop. The respondent shall verify whether the petitioner has secured enough marks to be appointed against the remaining 158 vacant posts under the CAPFS reserved for the SC category candidates, after comparing his marks with other SC category candidates. After comparing his marks with the marks obtained by other SC category candidates who have also breached the cutoff marks required and who have also not been appointed to the SC category posts. The entire the decision taken by the respondent number 3 should thereafter be communicated to the petitioner. The entire exercise should be carried out within a period of 3 months. 3, I was going to give 4. 4 months from the date of receipt of a certified copy of the file.
It should not be a precedent lordship. Otherwise, lordship floodgates will be open. As per 18, we have seen lordship.
No, you see, what you can do is you can make out a list now, because there are 158 posts, vacant posts. Now you make out a list who has to fill up the 158 posts. Because once you do that, when you're comparing, naturally you'll be making a list. So that will in fact help in the other cases also. That's why I'm giving you 4 months. With petitions accordingly disposed of. What is your case?
Yes, the petitioner were initially appointed as fireman Mailat in ONGC Mailat. Thereafter, Mailat, some promotional policy was made in 1997. That was silenced Mailat.
That was challenge.
Yes, Mailat.
You're a fireman. That's a class 4 post, a grade 4 post, or grade 3 post, or what?
Class 4 Mailat.
Then
Mailat, page 45 Mailat.
yeah.
It was Mailat Recruitment and Promotional Regulation 1980. That was amended Mailat. Page 45.
What is your grievance?
Yes, my grievance is Mailat. Initially,
No promotional post.
yes, when we are joined Mailat, that Mailat, there is a Mailat chance of Mailat to fire inspector grade 1 Mailat. Now Mailat amendment policy Mailat, they have Mailat close my promotion at ship fireman Mailat. That was my grievance. As ship fireman Mailat.
A chief fireman.
Yes,
That is higher than fireman.
yes.
Then what is wrong?
Then Mailat initial, when we are joined Mailat, when we were joined Mailat, then Mailat promotional policy was Mailat, we had a chance to go higher inspector grade 1 Mailat. That was case. The similar case was pending Mailat. It was Mailat notice.
So what is to be done? No, you tell me, what is your case?
Yes, my
There is
case-
a promotional post for you. Then what is wrong?
No, Mailat.
Huh?
Now amendment policy Mailat made, we have to chance only go for ship fireman Mailat. As
So
per 1997 Mailat.
So,
But
what is wrong?
initially, when we joined Mailat, that was some policy Mailat. That
what
was,
is your right?
that was Mailat fire inspector Mailat. Go to fire inspector grade 1.
From fireman,
Yes,
what is your next promotional post earlier?
yes, Mailat, that was Mailat. Earlier Mailat, page Mailat, 53 Mailat. Fireman grade 3, that thereafter fireman grade 1, thereafter fireman grade 1, thereafter fire.
So no,
supervisor.
what is the initial post? Fireman grade 4.
Yes,
And then from fireman grade 4, you are promoted to fireman grade 3.
Yes, my lord.
Then from grade 3 to grade 2.
Yes.
Then grade 2 to
grade
grade 1.
Yes.
Then grade 1 to.
No, my lord, that in that stop.
So what is wrong now? What do you want?
Now, my lord.
What are you, what post are you holding right now?
Yes, now, my lord, chief fireman, my lord.
Mr. Council, please understand. What is the post you are holding right now?
Now, my lord, deputy chief fireman.
You're deputy chief fireman. So you want to be promoted to, your next promotional post is what?
Yes, now, chief fireman, my lord.
Chief fireman. So there is the post of chief fireman is there. So what is wrong?
Now, my lord. When we joined, my lord, that was my case, my lord. As fire inspector grade 1.
Mr. Council, how many petitioners are here?
Two petitioners,
Two petitioners. Petitioner number 1 is holding what post?
chief fireman, my lord.
Chief fireman,
No, deputy chief fireman,
deputy chief fireman. Petitioner number 2 is holding what post?
deputy.
Deputy chief fireman. What is the next promotional post for deputy chief fireman?
As per 1997 amendment rules, chief fireman.
And now?
Now, my lord, 1997 amendment, that was, my lord, existing, my lord.
Huh? Yes.
That was existing, my lord, 1997 amendment, my lord. That's chief fireman, my lord. Before that, my lord, fire inspector grade 1.
So anyway, you still have got a promotional post. So what is wrong?
Yes, my
What right of yours has been violated?
that is, my lord.
I thought you had no promotional post. What is wrong?
Actually, as per the OM lordship 2010 lordship, all the group B posts have been replaced with group C posts. There is no longer group B post lordship.
Group D.
Group D. There is
Earlier there was group D
It has
post.
been merged with group C post.
So now he's in a group C post
Yes, Lord.
from group D.
Yes, Lord.
So what is his grievance? What is your grievance? You have got a promotional post. Your earlier post, which was a group D post, has now become group C post.
Yes.
So what are you?
Now, my lord, in group C post, my lord, that is chief fireman, my lord. That was, my lord, closed, my lord. We have no chance to group D, my lord, group A, my lord. That is my case, my lord.
Mr. Council, first you become chief fireman, then you think about your next.
Thereafter, my lord, no promotion.
Maybe, but you see, right now you have got no right to be promoted beyond
Yes,
the chief. So your writ petition is premature. It is like this.
Yes.
You are an assistant sub-inspector of police. Your next promotional post is sub-inspector, then inspector. Before you are even a sub-inspector, you are saying that you don't have chance of promotion to become inspector. First you become sub-inspector, then only we will think about your right to become inspector.
as per my lord, my submission before your chief, my lord. After my lord, chief, my lord, fireman, that is group C, my lord.
Mhm.
After they have closed that. After group C, after chief fireman, my lord, there is no chance to.
Go beyond.
Yes, that is-
But that bridge will come when you have got a right. Right now, you are not even chief fireman.
Yes, I deputy chief. fireman.
Yes. And this is not a PIL. Right, as on today, no right of yours has been violated. What right is violated?
My lord, initially that was, my lord, when we joined, my lord, there is a promotional policy, my lord. In that, my lord, policy, we have the chance, my lord. That is
You
my
have a
case,
chance
my
to
lord.
become what? Inspector.
Yes, my lord.
From,
Fireman
from
inspector,
deputy chief inspector, from deputy chief inspector to inspector.
yes, my lord. I
Then-
had the chance at that time.
Then after inspector, you become what?
No, that is, higher inspector, my lord, that was closed, my lord. There is, after that, no promotion, my lord.
Show me the rules. I
Yes.
am not understanding what you're trying to. What is the relevant rules right now? What
Yes,
is the
my lord.
valid rule?
Page 45, my lord.
Page 45, yes.
Yes, my lord. Recruitment and promotion regulation 1980, my lord. That
Ah.
is, relevant portion is page 49, my lord.
49, yes,
Column number 19,
yes.
column number 18, chief fireman, my lord.
Ah,
That is,
18.
we have to come from,
Okay, from chief fireman,
Yes.
You become deputy chief fireman. How can it be?
No, no, no.
No,
Lordship,
no.
from deputy chief fireman, you become
fireman.
chief fireman.
You chief fireman.
Chief fireman is.
So right now you're deputy chief fireman.
Yes, my lord.
So chief
Now-
fireman post is still there.
Yes, my lord. Still there, my lord. And
6 years qualifying service.
Then from chief fireman, there's no other promotional
yes.
post. That is your case.
Yes.
Now in the earlier
earlier, my lord,
yes.
page 51.
page
51, my lord.
51.
Prior to the existing regulations, my lord. My lord.
Earlier
Yes.
there was
Yes.
where?
Page 52, my lord.
Ah.
Relevant person.
Okay, there was no deputy chief fireman.
No.
So how does it, so what is wrong? What is the pay scale of a deputy chief fireman?
Yes. Yes. That is, my lord, open ended, my lord, 13,770.
Deputy chief fireman, 13,000.
70, my lord.
Then 13,000 to what? What is the upper limit?
Yes, my lord.
Is. Lordship, from page 64, it reflects that lordship, for the post of deputy chief fireman, the pay scale is 15,000 to 35,000.
I do not know what he wants.
From
I
page
am-
64.
I'm-
Yes.
Mr. Council, there was no deputy chief fireman earlier. That is your
No,
case.
yes.
Huh?
Yes, no deputy.
So this is a difference in the nomenclature, in the name. How does it, how does it, how is it causing you any prejudice?
Yes, my lord.
What yes?
There is earlier no deputy chief fireman.
So how does it matter? You don't like the name deputy chief fireman.
That is,
What name do you want? Super chief minister or something like that. What do you want? No, tell me your problem. I don't understand.
my lord, that is in earlier.
What is
policy-
his problem? What is the case? What is he trying to do?
I am appealing for respondable one and the ministry lordship. The grievances against the ONGC lordship. ONGC have some policies lordship and accordingly they have, according to the government of India's OM, lordship, they have merged the categories. Now it has become lordship, all the categories have been merged because there is no longer group D category. So those posts has to be merged with something. That's why they have merged with the group C post, and that is the grievance they are saying that lordship, there is no promotional revenue lordship.
No, he said there's a promotion level. He's a deputy chief fireman.
Yes, lordship.
He's showing me the route.
Sorry,
there's
group C only,
a-
Yes,
there are certain diversion and there are certain cadres are there watching group C only lordship. And they have promotional revenues lordship.
You've got a promotion level. I don't know you tell me what right of yours has been violated. Just because of a change of name, change of nomenclature. Don't file a case just for the sake of filing, Mr. Counsel.
My lord, page 15, my lord. Para 20, my lord.
50,
Yes, my lord.
5015,
15, my lord. Para 20, my lord.
para 25.
20.
Yes.
That the petitioner begs to state that they were appointed in the year 1994 as fireman grade 3 and after serving 6 years as fireman grade 3 in the year 2000, on 29/12/2000, the petitioner were promoted to fireman grade 2 post. Thereafter, in the year 2007, that is on so and so, the petitioners were promoted to the post of fireman grade 1 after completion of 6 years service as fireman grade 2. That though the existing MRPR.
Mr. Counsel, you see, one thing, you are saying that instead of being promoted as so and so name, as supervisor, you have been promoted as senior fireman. How does the change of name prejudice you? how is it to your detriment? You have got to show that your pay your pay scale, that which you were supposed to get, maybe has become lower. But just because they changed the name, that is that cannot be a ground to challenge the new rule that has been made.
Well, only on Friday like that.
No, you tell me now. Why Friday? If you can't explain to me now, you cannot explain to me on Friday also. I'm giving you this much time. I'm still not getting it.
Okay, prior to 2010, Lordship, there was 2 posts and they were being promoted in the, I have no dispute with the paragraph 20, Lordship, the what my learned friend is reading. But after 2010, things have changed, Lordship.
That's changed, but
Yeah,
how
Lordship,
does
the
it
base case has not been
affect
affected.
the petitioner? How does it affect you? Please show us. Please show me how it affects you. Just because instead of a senior fireman, instead of a fire supervisor, you are known as senior fireman. How does it affect you?
Yes, my lord, there are 21, my lord. The petitioner was that thereafter in the year 2012.
No, there's nothing.
The petitioner were promoted to the post of senior fireman instead of fire supervisor post. As per the RNP.
No case is made out, Mr. Nair. What you do is, you see, the only thing I can find is that your two main points are that there's a change in name. Instead of supervisor, you have been made senior fireman. And then your other point is that after chief fireman, there's no promotional post. But right now, you are a deputy chief fireman. You're not even a chief fireman. But so there is a promotional post for you as on today. So what prejudice is there? So either you withdraw this and you think of coming with a better petition, showing that some right of yours has been violated, or I dismiss this petition. There's no case, no locus. I do not know. You see, you just cannot file a case just like this.
Allow me to withdraw.
I don't know actually whether I should allow you to withdraw. So there is no case out there.
Same matter was pending, my lord, and it's on 8/11.
Maybe we'll see that when it comes. But now there's nothing here. Right. Heard, Mr.
I'm Kalita.
M. Kalita, learned counsel for the petitioners to submit that he may be able to withdraw the writ petition with liberty to file a petition. Mr.
DJ Das, your Lordship.
DJ Das, CGC appeared for the point number 1. The petitioner's grievance is that the promotional post of a deputy chief fireman is chief fireman, and that there is no further promotional post for the petition. So he submits that the petitioners are holding the post of deputy chief fireman as on date, and their next promotional post is chief fireman. As the petitioners have not even been promoted to the post of chief fireman, this court is unable to understand as to how any prejudice is caused to the petitioner as on date. On the prayer of the petitioner's counsel, the writ petition is dismissed as withdrawn, with liberty to file. 15. Yes, what is your case?
Removal from service
Why?
on account of bigamy without divorcing my first wife. I had solemnized the second marriage.
You're in the police.
Yes, constable.
So what is wrong?
Wrong is
Because of violation of the conduct rules. Then what is wrong?
wrong is that the departmental proceeding was not conducted in accordance with the law. Because the rule 9 of the disciplinary, rule 1965, gives me liberty to have my defense witness.
Huh?
Rule 9, sub-rule 6 of the services and discipline rule 1965. As per the said rule, I am entitled to have my defense witness during the departmental inquiry.
Okay, that is the technical part. You are entitled to have a defense witness.
I have so many.
No, you see that the out here, we are not, I think there is no dispute with regard to facts. Correct?
The facts I'm coming.
No, you just said
But
the fact.
that part is admitted that the second marriage has been solemnized with the consent of the,
With the
first
first
wife.
wife, okay.
and
So now, what does the conduct rule say?
rule 26 says that no person is allowed to have second wife during his first wife.
Then,
But issue is that the rule does not say that the person shall be terminated from the service, and there is a catena of decision passed by this honorable court.
by this court, okay. Show me.
Lordship, that is the rule,
Yes, there is the rule.
26. In fact, rule, they have also. Lordship, my first peruse the removal order.
Just a minute. Yes, Ms. Bhattacharjee, any judgment?
Lordship, right now I am not having
Anyway,
a judgment, Lordship,
anyway.
but it is an admitted fact that Lordship, he has married Lordship. And if there is any lacunas in the inquiry Lordship, there is provision Lordship, it can be initiated de novo Lordship. This
That
is also
appeal-
their
that
Lordship.
Highlighting the lacuna, I had filed an appeal as per the provision of the rule 15, and that appeal has been dismissed without the issues which I have raised at the time of appeal. And Lordship,
Just a minute, just a minute. I will hear you, don't worry. Okay, tell me.
Lordship may peruse the removal order, page 37 of my petition,
Page 37.
page 37. In the first, second, third paragraph,
This is the removal order
removal order.
dated.
The removal order dated 26th April 2022.
Yes, what does it say?
May I have your permission to read the relevant portion?
Yes, yes, yes.
I am reading the third paragraph of this order. The delinquent was again asked to reply the findings of the inquiry officer on the examination of the reply of the final show cause submitted by the delinquent. It was found that nowhere in his reply has been able to show that he had solemnized his second marriage with Srimati Nasrina Begum Laskar by following the proper rules, which enumerated in the Rule 26 of the Assam Civil Service Conduct Rule. He is contracting second marriage while his first wife, Srimati Shahida Akhtar Barbuya, is living, and without obtaining a divorce is in gross violation of the service rule, therefore gross misconduct. Now the Rule 26 for the sale of Lordship may peruse. Delegation of power.
The government general, the
Let
government,
us see rule 26. Give me the Assam Civil Service Conduct Rules. Let us see that, just show the cover of the book so that they can look for it.
Lordship, this is there.
Do we have that kind of book? No. Yes. Delegation of powers, yes.
delegation of power. The government may by general or special order direct that any power exercisable by it or any head of department under this rule except within bracket, except the powers under Rule 23, and this rule shall subject to such conditions if any as may be specified in the order be exercisable also by such officer or authority as may be specified in order. But the Rule 26 does not say anything about the Vaigami. Vaigami is about the Rule 24. But if I peruse the Rule 24. That the no government servant who has a wife living shall contract another marriage without first obtaining the permission of the government, notwithstanding that such subsequent marriage is permissible under the personal law.
So you mean to say there was a mistake in mentioning the wrong provision?
That,
law.
yes, that is admitted because as per the rule and as per their.
So that does not vitiate the order.
No, I'm not on that. I'm just highlighting that issue. The order is vitiated on the ground that first, I am entitled to have my defense witness. Rule 9, sub-rule 6 of the Assam Service and Discipline Rule 1965 says, and rule also says that if the inquiry officer denied the right of defense witnesses, the reason has to be recorded in the writing.
But 24, 26, he'll hold it down. 24, 26.
Lordship, may I proceed, Lord?
Yes, yes.
And this rule says that if such opportunity is denied, then the reason has to be recorded in the writing. And the inquiry report shall reveal that no such finding is there, why the opportunity was denied to have the defense witness. And the rule 9(5), 9/sub-rule 5 says that there must be a presenting officer. There must be a presenting officer. In my case, there was no presenting officer. The inquiry officer himself presented the case, and he was a prosecutor as well as the presenting officer. And this is the violation of the principle of natural justice. And this inquiry, Lordship, this bigamy is not a misconduct. Bigamy misconduct is something different. If someone neglects if someone neglects to perform his duties, then it may be termed as a misconduct. Bigamy, this is not my submission. I am submitting. I am with the decision passed by this honorable court that I will place, Lordship. That this court also observed that bigamy is not a misconduct as per the service jurisprudence. And these points are highlighted. While I have preferred the appeal, but without addressing the same, the appellate authority passed a blanket order dismissing my appeal. And another important aspect of my case is that Lordship will find in the inquiry report is page 32.
Page 32.
Page 32. I'm reading the clause 3, 4, 5, 6. Clause number 6. According to the rule 2 within bracket B of Assam Civil Service Conduct Rule 1965, which defines a government servant to mean any person appointed by government to the civil service or post in connection with the affairs of the state. Again, according to Rule 26 of Assam Civil Service Conduct Rule 1965,
no government servant who has a wife living shall contract another marriage without first obtaining the permission of the government, notwithstanding that such subsequent marriage is permissible under the personal law for time being applicable to him. Further, that part is important. Further, Rule 3.5 of the Assam Police Manual Part 3 states that all subordinate police officers are directed to acquaint themselves with and to observe the rule laid down by the government for the conduct of the servants. That is the subordinate police officer. And the police officer, this rule may be read in term with the Rule 4 of the Part 3 of Assam Police Manual, which defines the cadre of the Assam Police, and Rule 3.5. As per the Rule 3.5, I am not a subordinate police officer. I am not a cadre of the police. And this is the observation of this honorable court.
You are not a cadre of the police?
That
What
is-
are you?
That is defined by the
No, you are working in what department?
police constable.
You're a police constable.
Yes.
Unarmed branch or armed branch?
Armed branch.
Armed branch. Police constable, armed branch.
Yes.
So that according to you, you're not in the police cadre.
I am not.
Then what cadre are you?
As per the Rule 4. Cadre as per the lordship. The Rule 4 of the Assam Police Service Rule 1966. Cadre, it is categorically defined. The cadre of the service shall comprise the following categories of post. The junior grade 1, Deputy Superintendent of Police, Assistant Commandant of Armed Police Battalion, such other posts which may be declared as equivalent to those posts by the governor. No, but such declaration is not available. In the senior grade, Additional Superintendent of Police, second in command of Armed Battalion, and such other posts which may be declared by the governor or the equivalent to this, to any this post. So as per this rule, constable, position of the constable is to be determined by the government. Sorry, governor of Assam. And this,
So according to you, you are not governed by any conduct rules, are you?
I am governed by the conduct rule. That is true, but I am not the subordinate police officer as they have mentioned. And lordship, the most important part is that is the legal part. That is that whether the biogamy is amount to misconduct or not. Because there is a, as per the Rule 7 of the discipline rule, there is some other list of punishment which may be imposed, but the extreme punishment in terms of biogamy, this court is observed in the Katina decision that extreme punishment may not be imposed considering the fact and circumstances of this case because the biogamy does not amount the misconduct. And my case is something different, lordship. That is, admitted position is that my first wife, she on two different occasions.
Your first wife gave you permission to marry. That's your case, correct?
That is true. And why the permission is given, that background is to be considered, may be considered. On two occasions, she has given a birth to two stillborn baby without life. And the clinical diagnosis proved that because of certain medical issues, she is unable to give birth to a child. Thereafter, she gave me permission. Accordingly, I have conducted marriage. And when I conducted marriage, then she changed the position. So I am not on that part because the rule says that no government, permission from the government is required. But the only issue is that the defense witness is denied. First, second, there was no present.
Denied what? Denied what?
I was
Defense
not
wit-
allowed to have my defense witness.
No, even if you had a defense witness, what was your case going to be?
That permission part, when she was given permission, that it was after the discussion with the family members, the permission was given by my first wife.
So permission was
elderly
given by
man-
the first wife. So You wanted to show that permission was given by the first time, by adducing your evidence.
And this another important part is the lordship.
Yes.
That I have. Lordship may peruse my appeal on the page
Yes.
number 41.
Page 41.
Yes.
Yes.
That I have raised certain issues which are most vital legal issues.
Hmm.
Lordship may peruse the page 44. Clause number 8.
Yes.
By declaring the appellant as a violator of the service rule and gross misconduct in light of the rule 24, I have corrected it. They have mentioned that rule 26. The Assam Civil Service Conduct Rule 1965, the inquiry officer failed to appreciate the fact that bigamy does not amount to misconduct for the rules required to prior permission of the authority to enter into a second marriage. And in the present case, it is not the finding of the inquiry officer that the second marriage of the appellant was without the permission of in such circumstances, the order of removing from service is contended to be legally invalid. The second, next paragraph, the law is well settled in case numbers 1995 to GLR 388, Profulla Kalita versus Oil and Natural Gas Commission, Dehradun and ORS. The allegation of bigamous marriage not being connected with the performance of duties by the concerned incumbent, even if such marriage had been proved in a departmental inquiry, the same cannot invite the extreme punishment of dismissal. The apex court in the case of Ramana versus FPSRT and others held that misconduct is in the context of performance of duties of the post held by the
What is
incumbent.
this Ramana was APRC? What is this? What is the citation?
This Ramana citation, Lordship, it may be part of the Profulla Kalita's case. I'm just trying to find out. That I'll furnish Lordship. Presently, I skip to mention the citation. Lordship, I may be allowed to place two decisions passed by this honorable court, which are relevant.
Yes, you can. Please do. Yes,
Yes, Lordship, this first Jagadish Chandra Nath.
yes.
Lordship may peruse the page number 3, paragraph 6.
Give us also.
Yes.
Thereafter, by order dated so and so, the reserve officer, police reserve office of the superintendent of police Gwalpara had appointed Sri so and so of the Gwalpara as the inquiry officer of the departmental proceeding number so and so, grown up against the petitioner for inquiry,
The petitioner has annexed the typed copy of findings of the departmental proceedings so and so drawn up against the petitioner as annexer so and so. On perusal of the same, it appears that the inquiry officer had examined PWS in which is suggested that there was no presenting officer. There is no mention in the departmental proceeding that any opportunity was given to the petitioner to cross-examine of any of 6 witnesses examined as DWS. There is also no record in terms of the Rule 9, Sub-Rule 2 of the Assam Service Discipline and Appeal Rules 1964, hereinafter referred as 1964 rules. The petitioner was asked whether he desired to be hired in person or that the petitioner was informed of his right under. The petitioner was asked whether he desired to be hired or that the petitioner was informed the right under sub-rule 5 of the Rule 9 of 1964 rules to avail the assistance of any government servant approved by the disciplinary authority. Moreover, no material has been produced by the respondent. I am relying on that part, Lordship, that the defense witness cross-examination, that part is recorded here that while deciding the case, that such opportunity, the similar situation in my case also no opportunity was given. Lordship may peruse the next paragraph number 8 of the same judgment.
Yeah.
Moreover, the categorical finding recorded by the inquiry officer in the departmental proceeding is that 23/3/2005, the delinquent constable married with one Srimati so and so as second wife without getting divorced of his first wife Srimati so and so in violation of the provision of the Rule 13(2) of the Police Service Rule 1966.
Yes.
Wherein it is clearly stated that no person who has more than one wife living shall be eligible for appointment to the service. However, the inquiry officer miserably failed to appreciate that armed branch constable cannot be said to be in cadre. That I have submitted just that armed branch constable cannot be a cadre of the Assam Police, whose posts are prescribed under the Rule 4. Therefore, which includes Deputy Superintendent of Police and upwards, no material is available on record to show that the post of AB Constable has been declared by the Governor of Assam to fall within the cadre of Assam Police in terms of the Rule 4, Sub-Rule B, Sub-Rule 3 of the 1966 rules. That part is most important, Lordship.
No. So are you governed by the conduct rules or not? That is the
No,
simple
that is
question.
every government employee is governed by the conduct. Then my position, I am not the cadre, that is also admitted as per the rule. And what is my position? The rule says that is to be declared by the governor.
Okay. Then anything else?
And next, Lordship, just next part, I may be allowed to conclude. Just two or three lines. Thus, the recorded by the inquiry officer finding is found to be vitiated by total non-application of mine. It may be relevant to mention that Rule 24 of Assam Civil Service Conduct Rule 1965 bars second marriage without consent from the government. However, that part is important. However, no opinion is given by this court as whether the Rule 351 Part 3 of Assam Police Manual refers to the hearing above.
Yes. Mr.
And Lordship, these issues were raised, I had raised while preparing the appeal, but without addressing those issues, they have passed a blanket order that appeal is dismissed. And these are the legal issues. This is already decided by this honorable court.
That's all.
That's right.
Okay. Right.
Lordship, I just want to say that maybe misquote of rule lordship.
Yeah,
That's what.
that-
Yes, only the typo
That
makes
does
it.
not,
And the
yes, so
fact
there are
remains that
enough judgments.
without divorce, he has remarried and this is.
No, he's not denying that.
Yes, he admit his own admission.
No, no, I am admitting and I am
And if
also
there
at
is
the same
any,
time.
His only case is that he
if
did
there is
it-
any flaws in the.
he did it with the
inquiry,
permission of the
Yes.
first wife.
This is
That is
separate,
your
but the
case.
fact remains that
And-
without divorcing.
Now that part, that is right from the beginning, I cannot deny that really. That is true. But my submission is that polygamy does not invite the extreme punishment as it is decided by this honorable court in Katina's decision.
But what about the Supreme Court?
I'm not aware about the latest decision of the Supreme.
Not late, very old decision. Not very old. 2015.
And that part, Lordship, that procedural lacuna. That is also important. While conducting. the
Mr.
depart-
Counsel, when you have not denied the fact that you have committed bigamy, what more do you want?
That part, Lordship, that is why I had submitted.
I
that-
can understand when you say that you have not committed bigamy, then okay, the procedure violation, technical defects can play an important role. But when you have admitted to the fact that yes, you have committed bigamy with the permission of your first wife, we'll have to see the effects of that admission that you made. That's all. Because you are not denying the fact. It is not your case that you have not committed. I'll just read one paragraph for you. As already mentioned above, there is adequate material on record in support of the charge against the appellant that he performed the second marriage during the currency of the first marriage. Admittedly, there is no intimation in any form on record that the appellant had divorced his first wife. In service record, she continued to be mentioned as the wife of the appellant. So. In these circumstances, the finding of violation of the conduct rules cannot be held to be perverse or unreasonable so as to call for interference by this court. In these circumstances, the High Court was justified in holding that the penalty of removal cannot be held to be shockingly disproportionate to the charge and established judicial parameters. Anyway, so this is it.
Lordship, I last, I may be allowed to, okay.
I know, I'm going to pass the judgment order and you can read it.
So that part that I have referred the two decision passed by this honorable court.
That is High Court, single bench, this is division bench. I mean, this is Supreme Court,
No, it is a 2015, the decision, that is why,
2015 judgment.
that is why there may be some other decision.
Then there is my decision in on the basis of this subsequently.
Lordship may give me two, three.
No, it is of no point. You can read the judgment. If you find that it is wrong, you can always go to the division bench. Justice Rishikesh Roy also has passed the judgment in this. in
Lordship will
this matter.
dismiss after 3 days. That.
No, why
make
waste
any
time?
difference.
Why
That-
waste
So
time?
that I may.
No. You read it. I've read it. That's why I don't want to waste time. Why did you think I give you so much time to read, to argue the matter? Not for adjourning the matter, to take a decision. Why waste the court's time and others' time? Right. Heard Mr. F.Z. Mazumdar, learned counsel for the petitioner. Also heard Ms. M.D. Bora, learned counsel for,
M. Bhattacharjee, Lordship.
sorry. M. Bhattacharjee, learned counsel for
All the respondents.
all the respondents. Yes. the petitioner's case. The petitioner is challenging the impugned order dated, where is that removal order?
That order is on page number
Impugned order dated
37, page 37.
26/4/23. Passed by the Superintendent of Police, Dima Haflong, by which the petitioner has been removed from service on the ground of having solemnized his second marriage while during the currency of his first marriage. The petitioner's counsel submits that it is not in dispute that the petitioner had contracted a second marriage during the currency of his first marriage. So, however, the disciplinary proceeding that had been initiated against the petitioner is liable to be set aside along with the consequential order of removal, inasmuch as the petitioner was not allowed to present his defense witnesses. He further submits that no presenting officer was constituted in terms of Rule 9 of the Assam Discipline and Service Rules, 19.
1964.
Conduct rules of 65.
65. He
No,
submits,
it is not, also referring about the service and discipline rule.
Yeah.
Conduct rule.
Yes.
64.
64. First of, he submits that the petitioner, who is a constable of the armed branch of the Assam Police, is governed by the Assam by the Assam Civil Service bracket conduct bracket close rules 2000 what
1965.
1965, even though the the petition, even though the petitioner does not belong to the cadre of the police service, is it?
Yes.
Cadre of the police service.
In term of the rule 4 of the Assam Police.
In
Assam
terms
Police
of,
Ser-
in terms of rule,
4 of the Assam Police Service Rules 1966.
yeah. You got it. He also submits that bigamy is not a misconduct. And as such, the petitioner could not have been removed from service only because he had contracted a second marriage during the currency of the first marriage. So, in support of his submission, the learned counsel has relied upon. The learned counsel for the petitioner has relied upon the judgments of this court in Jagadish Chandranath versus State of Assam and others, reported in 2019 for GLP 1006, and in the case of Prafulla Kalita versus Oil and Natural Gas Commission and others, reported in 1997. See, no, 1995. 52 GLR 380. Miss M. Bhattacharya, learned counsel for the state respondents and the other and submits that the petitioner having contracted a second marriage during the currency of the first marriage, the petitioner had violated the conduct rules, and as such, there was no infirmity with the decision of the disciplinary authority in removing the petitioner from service. Full stop. She also submits that though the impugned order of removal has quoted the wrong provision of law regarding the misconduct committed by the petitioner, that is Rule 26 of the Assam Civil Service Conduct Rules, instead of the correct provision, that is Rule 24, the mistake in quoting the wrong provision of law does not vitiate the does not vitiate or invalidate the impugned order of removal dated what is the date?
26th April.
26 April 24, 23.
23.
I have heard the learned counsels for the parties. The the admitted position of fact is that the petitioner has contracted a second, the petitioner who belongs to the Assam Police bracket arm branch bracket group, who belongs who is a constable in the Assam Police arm branch, had contracted a second marriage during the currency of its first marriage. Full stop. In fact, he is still married to his first wife even till today. Correct?
No.
The reason for contracting the second marriage, according to the petitioner, was that his first wife had given delivery to two stillborn babies.
Without life.
Huh?
Without life.
Without
Life.
stillborn means without life, stillborn baby. And as such, his second marriage had been solemnized with due permission being taken from his first marriage, first wife. Next paragraph. The said issue having been settled, the having been found to be correct, the disciplinary inquiry initiated against the petitioner culminated with the removal of the petitioner by the impugned order dated 24 April,
26th April.
26 April 23. The appeal filed by the petitioner against the removal order was also rejected. Full stop. The basic issue is whether there was any infirmity or illegality in removing the petitioner from an admitted position, where he had contracted a second marriage during the currency of the first marriage in violation of the applicable conduct rules. What's that? Next paragraph. In the case of Khurshid Ahmed Khan versus State of Uttar Pradesh and others, reported in 2015, 8 SCC 439. The Supreme Court has held the Supreme Court has, on considering the judgments passed by the judgments passed in other decisions of the Supreme Court, that the penalty of removal from service cannot be held to be shockingly disproportionate in respect of the charge where a person had, where a government servant had performed a second marriage during the currency of the first marriage. The Supreme Court in the above case of Khurshid Ahmed Khan Supra also considered the question as to whether the impugned conduct rules which prohibited a government servant having a living spouse from entering into or contracting a second marriage was violative of Article 25 of the Constitution of India. comma, keeping in view the personal laws available to persons professing different faiths. Full stop. The Supreme Court held that the Rule 21. No, the Supreme Court held that the Central Civil Conduct Rules 1964, which restrained any government servant from having a living spouse from entering into or contracting a second marriage, did not violate Article 25 of the Constitution. So, sir. Next paragraph. In the present case, what is this? Rule 24 of the
Assam Civil Service Conduct.
Assam Civil Conduct Rules, which is similar to Rule 21 of the Central Civil Services Conduct Rules 1964, restrains any government servant having a living spouse from entering into a second marriage. In view of the law laid down by the Supreme Court in Khurshid Ahmed Khan Supra. This court does not find any infirmity with the decision of the disciplinary authority in removing the petitioner from and for having contracted the second marriage while still having a living first wife. Then, okay, then in the case of, now I have to talk to about the High Court judgment. In the case of Jagadish Chandra Nath Supra, what did this court say?
Lordship may refer the Prafulla Kalita, which it says that bigamy does not amount to misconduct.
Wait, next para. In Prafulla Kalita Supra, this court had held, where in para?
Para 7, page 4.
Para 7 had held where?
The question of misconduct came up for the consideration before the Supreme Court.
Huh? Where does he say bigamy is not a misconduct?
I'm the essence of this entire paragraph.
This court in para 7 had implied that a bigamous marriage was not a misconduct. Then what about in this other was Jagadish Chandra Nath? What has it said? What has been said?
Paragraph number 8, page 4.
Now, what does it say?
It says that the essence of this paragraph is that the delinquent person is protected as under the rule code. Because he is not the cadre of Assam Police, therefore the rule 351 is not applicable in this case.
Does he say that the Assam conduct rules is not applicable?
No, Assam conduct rule is applicable.
That he says that, then what remains?
Rule 351 of the Assam Police.
What does
Manual,
351 say?
No person is allowed to have second marriage. Sorry, no subordinate police officer is allowed to have second marriage.
So? How does it support your case?
I am not the police officer that I am trying to establish. That my cadre is something different, which shall be defined by the governor.
Okay, right. In the case of Jagadish Chandranath, this court had held that a constable, is a constable out here?
Constable.
Was a constable was not a police officer in terms of
Rule 4 of the Assam Police Service Rule 1966.
where does he say that? I have not seen it.
Rule 351. Lordship, this rule 351, the language is that all subordinate police officers are directed to acquaint themselves with and to observe the rules laid down by the government for the conduct of government servants. But this rule says that the conduct rule is applicable in case of all the subordinate police officers. And my submission is that since I am not the police officer in terms of the rule 4 of the Assam Police Service Rule 1966, that is why the allegation of bigamy is not applicable in my case.
This court had held that. In terms of Rule 351 of Part 3 of the Assam Police Manual. Is it?
Yes, sir. That all subordinate police officers are directed to acquaint themselves with and to observe the rules laid down by the government for conduct of government servants.
Yes, he is a government servant, Lord.
That is
follow.
Am I denying?
No, so how does this help you?
Just I'm trying to point out that all subordinate police officers. That this code is held opinion that the constable is not a police officer in terms of the rule code. His
Where
position,
does he say that? Where does he say that in terms of Rule 4, he is not a police officer? Where does he say that?
yes, in the first paragraph of page 5, that is not.
Yes.
I'm reading the page 5. In violation of the provision of Rule 13(2) of the Assam Police Service Rule 1966, where it is clearly stated that no person who has more than one wife living shall be eligible for appointment to the service. However, inquiry officer miserably failed to appreciate that armed branch constable cannot to be said to be in cadre of Assam Police
Okay.
Service whose posts are prescribed under the rule code.
Okay, right. What have I said? Yes, read. No, has held that. Has held that. An armed branch constable cannot be said to be in the cadre of Assam Police Service.
Lordship, rule is misquoting, Lordship, and
No, it's okay. Assam Police
Section
Service.
2(1) of the Assam Police
Full
Act
stop.
2007.
However, no, full stop, though. However, the judgment of this court does not say that the Assam Civil Service Conduct Rules 1965 is not applicable to a constable of the armed branch of the Assam Police.
Lordship, as per rule two of the section 2 of the Assam Police Act, Lordship. The entire police establishment under the state government shall, for the purpose of this act, be deemed to be one police force and shall be formally enrolled and shall consist of such members of officers and men and shall be constituted.
No, that is
such
not
men.
denied.
Yes,
As per rule 2
Yes,
the-
Lordship.
of the
Assam Police Act, Lordship. In page 49 of the writ petition, Lordship, there is a reference in column B, Lordship. The last page.
Okay, next, right. So the impugned order dated 26/4/2023 as referred to Rule 26 of the Assam Civil Service Conduct Rules 1965. Relating to the bigamous marriage of the petitioner, comma. This court is of the view that the mention of the wrong provision of law instead of the correct Rule 24 of the Assam Civil Service Conduct Rules does not reshape the validity of the impugned order, comma, in terms of the judgment of the apex court in dash versus dash. In view of the reasons stated above, this court does not find any merit in the writ petition. Full stop. No, comma, the same is, full stop, the same is accordingly dismissed. Yes, what?
Unusual prayer, my lord, this case, my lord. Item number 38 and 39, my lord. In both the case, my lord, we have to file affidavit in content case, my lord. Already the medical examination has been done, as per the court order, but we have to make it.
Which matter is this?
Item number 38, 39, content matters, my lord.
Okay,
My lord, I have some person difficulty.
When? okay. Item 38, 39. Why if the medical examination is done, why 3 weeks?
My lord, yes, they are, my lord, actually that, my lord, it was done within 2 months. Subsequently, again, one review medical was done. But court has directed for once only. We have done twice. They have some.
So if you have already done, why do you want 3 weeks?
For the affidavit.
Yes, for the, any objection?
No, Lord.
Okay, Mr. KK Parasar, Clerk Counsel for the respondent,
Number 2.
number 2, is granted 3 weeks time to file affidavit regarding the medical examination done on the petitioner. Mr. H. Bes Barwa appears for the petitioner. List the matter after 3 weeks. Item 38, 39.
39. I'm obliged.
Obliged, your lord.
This I will dictate some more. Later.
And we can change.
Yes, what is their case?
Well, the petitioner actually initially when he was appointed as a worker section assistant, my lord,
Yes,
page 11, my lord.
yes.
Thereafter, my lord, his service was extended, lordship, kindly page 16, my lord. Time to time extended by the authority, my lord.
Yes.
Thereafter, my lord, again, he was transferred, my
Where is
lord,
the initial order?
lordship at page 11, my lord. Annexure 1, my lord.
Okay.
Thereafter, my lord, he was extended time to time, my lord, he was transferred, my lord, by the order dated 8/8/1994, annexure 3, page 19, my lord.
Transferred in 94 then.
Yes, then, my lord, there was, lordship, some area outstanding, the authority did not release their salary, my lord. Then they filed a writ petition, the Honorable High Court, lordship, kindly see at page 22, my lord.
Yes.
Thereafter, my lord, after filing this.
Where are you? Are you a party here?
My lord.
Are you a party in this writ petition 3068?
It is, my lord, as far as information, he was party, my lord.
As per, no, that was, just look out there. Just look in, civil rule number 3068 of 1994. It won't be here, it won't be here. This is different. This is different. 3068 of 1994.
My lord.
Just see who are the petitioners.
My lord, earlier, my lord, there was system was different, my lord.
I just want to know who are the parties, whether you are party or not.
In this lordship, I have next certified to be page 24, my lord.
Page 24.
My lord. They are only mentioned Rajiv.
No, Mr. Counsel, whether you are a party here.
And subsequently, my lord, I have
Just a
another,
minute.
another orders, my lord.
Can it be there? Can be seen in the computer? Parties names. In civil rule 3068 of 1994.
Offline, my lord. There's no one.
They are scanned, Mr. Counsel. Yes.
Thereafter, another orders also, my lord, even next, my lord.
Now you are asking for reinstatement, correct? So you have not been working since when?
Since 1997, my lord.
Since 1997,
My lord.
and you have not been getting your pay since when?
Lordship. Thereafter, they received salary up to 1997, my lord.
How do you say that?
Lordship, after filing this case, my lord, he received, my lord, the area salary, my lord. Thereafter, his service was terminated, my lord.
Where is the termination order?
Lordship, kindly see. That page, lordship. Page 18, my lord. Sorry, 25, my lord, page 25, my lord.
Yes.
You are hereby appointed so and so on purely temporary basis, works as employee, and as your service are no longer required by the council, it is not possible to pay salaries for your services. You are informed here with
So your service terminated from 97.
97, my lord.
Then now what do you want?
Then, my lord, they filed a requisition with the Honorable High Court, my lord.
Ah.
Lord, you kindly see at page my lord, 30 onwards, my lord, 30, my lord. 30, there is a miscase, my lord, 584, 1997, my lord.
Yes.
Here, my lord, petitioner serial number is, lordship kindly page 36 serial number.
Yes.
Yeah, yes, my lord. And another.
Where?
petitioner,
At 30?
At page 37, my lord, serial number 36.
Why is the miscase not here? Miscase should be with this. Give me this. Is there any miscase with this? How come there's no miscase? Miscase number 584 of 1997. This option. It is, how come it is, miscase is in which case? In the civil rules,
Civil rule number 521.
but it is not here, it is not with this. Then what happened?
Lordship, thereafter honorable court passed an order, my lord.
Hmm.
Page 39, my lord, order.
Ah.
Order.
Yes,
Page 39, my lord.
yes, what does it say?
Following the out this petitioner, another petitioner. employee-
39, there's no order. 39 is just parties' names.
Page 39, my lord.
Okay, 39, yes.
Yes, my lord. Here, my lord, the law is that the one set of ad hoc employees shall not be replaced by another set of ad hoc employees if there is the necessary of the employee. The petitioners along with other similarly situated persons shall be engaged, but no fresh person shall be engaged, my lord. Then we can dispose of, my lord.
Okay, so,
Thereafter, my lord, it petition also dispose of, lordship kindly see page 49.
but where is your reinstatement? Where is your reinstatement order? You are not reinstated.
Not restated, my lord.
So you are not reinstated despite the order passed in 98.
My lord.
Then,
Then, my lord, lordship, again, the petition, again, the one, lordship, in this case, lordship kindly see page, my serial number is 41, 36, my lord. My serial number is 36, page 37, my lord. In the miss case, my lord.
yes, yes,
And another petitioner, my lord, page 38, serial number 41, my lord. In the same case,
yes,
he filed a petition with the Honorable High Court in 2020, 2000, my lord.
2012,
2000, my lord,
2000.
my lord.
Ah.
Lordship, you kindly see at page, lordship, 54, my lord.
Yes,
Co-petitioner filed a petition. And after passing this order, my lord, she was reinstated, my lord. So I am
who is
saying
the
that
petitioner? Petition
Petitioner-
Munisa,
petitioner is my lord.
41, okay, so what was the order? This
Whatever,
is in the year 2000.
my lord.
For his reinstatement,
Yes, my lord.
and now what do you want?
Accordingly, you are reinstated, my lord. You are,
So you want that same order that was
My
passed
lord.
in the year 2000 should be passed now?
thereafter, my lord, I have filed a several representation before the authority, my lord. The authority is not considered, my lord. Still I am
Now,
waiting, my lord. Still awaiting, my lord.
still awaiting, you wait for another 20 years. What? How can you keep on waiting like this? Where is your case? You were terminated in 97.
So, lordship, my ample clear, lordship, my last representation may be considered, my lord. As per
No,
law,
no, no,
my lord.
no, there's too much delay. I'm dismissing your case. Heard. Otherwise, you want to withdraw, allow it to withdraw, that's all, but no, no liberty.
It is not no fault from his part, my lord, because they have been.
There is
working, my
one,
lord.
you,
The authority will
you heard
consider.
of Mr. Rip Van Winkle? Have you heard of Mr. Rip Van Winkle?
I have filed representation, my lord.
Have you heard of him?
My-
Have you heard of Mr. Rip Van Winkle?
My-
You have not heard. He slept for 20 years. In your case, you have slept for more than 23 years. Heard Mr. R. Mazumdar.
Jail Oscar, my
Huh?
lord. May Jail Oscar on behalf of R. Majindar, my lord.
Miss, huh?
I am Mr. Jail Oscar, my lord.
You are J. Laskar.
That's all.
Heard Mr. J. Laskar appearing on behalf of Mr. R. Mazumdar. You are not even the counsel. Appearing on behalf of Mr. R. Mazumdar, learned counsel for the petitioner, who submits that the petitioner's service as a work charge employee had been terminated while where is the termination order?
Lordship, that is 25 my lord.
Had been terminated while order dated 8/1/1997. He submits that the petitioner being aggrieved along with other persons had filed civil rule number 521 of 1997. Civil rule number 521 of 1997 was disposed of by order dated 14/11/22. By directing the respondents to consider the case of the writ petitioners for regularization of their service against available vacancies if they were still in service in accordance with the office memorandum dated 30/10/2001. The petitioner's counsel submits that there were 42 writ petitioners in civil rule number 521 of 1997 and writ petitioner number 41 in civil rule number 521 of 1997 had also filed one writ petition, that is WPC number 489 of 2000. WPC 489 of 2000 had been disposed of by order dated 7/12/2000 by directing the respondents to examine and consider the case of the petitioner therein for reinstatement into service as a work charge sectional assistant or equivalent. Next paragraph. The petitioner's counsel submits that the petitioner had submitted various representations, the last one being submitted on 19/4/2019. To reinstate the petitioner into service. Accordingly submits that the writ petition may be disposed of with the direction to the respondents to consider the case of the petitioner, to consider the representation of the petitioner dated 19/4/2019. Next paragraph. Mr.
C Sharma Lordship,
C. Sharma, the learned counsel for the
respondent number 327.
3 to 7, and Miss
DS New Zealand.
DS Neo for
Correct,
respondents
sir.
number 1 and 2. Submit that the writ petition should be dismissed due to laches, due to delay in that. I have heard the learned counsels for the parties. As can be seen from the order dated 14/11/2002 passed by this court while disposing of civil rule number 521 of 1997, the state respondents were to consider the case of the petitioners therein, including the writ petitioner herein, for regularization of the service against available vacancies. If they were still in service. Full stop. However, as can be seen from the pleadings, the petitioner's service had been terminated. However, as can be seen from the pleadings, the petitioner's service has not been regularized despite the order passed in the year 2002. And no challenge has been made to the order dated 14/11/22 passed in WPC, passed in Civil Rule number 521/1997. Next paragraph. The petitioner's prayer in his representation dated 19/4/2019 is to reinstate him and allow him to continue to work as a work charge employee. However, the fact remains that the petitioner has not approached this court for the last more than 20 years. And as such, there has been considerable delay and latches in approaching this court. There is also no reasons given by the petitioner as to why he has approached this court after 20 years. In that view of the matter, now in view of the considerable delay and latches in approaching this court, this court is not inclined to exercise its discretion in the present case. So the writ petition is accordingly dismissed. Understood. Yes.
My lord, I'm sorry, I was not present in the workshop. I was on breaks in another court. Your lordship needed to know whether in WTC 86 of 2016, the prayer for the seniority was made. I was not the counsel, my lord, in that case, so we're not sure. Your lordship may peruse the prayer.
With retrospective effect.
Yes, that prayer is there.
Then,
And the
so it
order,
has not been given to you.
no, order passes, your lordship will find that page 54. I'm sorry, my lord. Yes, page 54. That's a very innocuous order.
So if you find, you see, since we have already made a prayer with retrospective effect, and you have not been given the prayer, the prayer has not been granted to you, then you challenge that order, you file a review.
Your lordship will kindly read the, my lord, I understand your lordship, my lord, perspective of this, my lord, situation, page 55, last paragraph. Your lordship will, that is the operative part.
May I read it, my lord?
Page 55.
Yes. This is the
Yes.
order ultimately passed. After the, my lord, review in the division bench, since the prayer by the petitioners in this case are limited to the consideration of their cases for promotion to the next higher post of assistant engineer in accordance with the rules referred to herein above. And the right to be considered for promotion to the next high post, subject to eligibility and suitability of the candidates as provided under the rules. It is a fundamental right. I therefore deem it proper to dispose of the writ petition by directing the respondent authority to consider the cases of the petitioners for promotion to the next higher post of assistant engineer from the post of junior engineer in the Department of Public Works, Government of Assam, in accordance with the rules governing promotion to the post of assistant engineer, along with others similarly situated eligible persons serving in the said department, which shall be completed by the respondent authorities within a period of 8 weeks from the date of receipt of the certified copy of this order. So, my lord, by this order only, my lord, their cases are directed to be considered. Now, the question that may come before your lordship is that, my lord, at that relevant point of time, when this order was passed, 16/6/2022, and prior to it, my lord, in fact, 22, it has been remanded back, and that's why the matter was there. When the writ petition was filed, at that point of time, my lord, the issue regarding the, my lord, the certificate obtained from the, my lord, the AMICE, whether that is valid or not, my lord, there was a doubt. And that doubt has been cleared only, my lord, by judgment of this honorable court in 16/11/2017. That order your lordship will find at page 72. So that issue was, my lord, see, it was still a, my lord, dark area, because, my lord, some questions arose whether that is equivalent to BE or not. Ultimately, my lord, this has been clarified by this honorable court and also by the, my lord, only the Council of Technical Education. And as your lordship, my lord, I don't know whether it was pointed out, under the rules, the junior engineers, my lord, is normally promoted after completion of a period of service of 8 years. And those who qualify to be appointed as assistant engineer directly, that is those who have B degree or equivalent, they are, my lord, considered out of dark. And in the same manner, my lord, in that following that procedure, two of the persons, my lord, similar to the petitioner, they were appointed, my lord, promoted in 2015. Eventually, my lord, there were quite a number of litigations, and they, my lord, whether the AMI certificate is equivalent to BE degree or not, that is no longer, my lord, res integra. That has been decided. And eventually, this petitioner has been promoted in the regular course of promotion without, my lord, going the out of dark. And now he is claiming that I ought to have been considered on the basis of my BE equivalent degree. That has not been considered, and I'm praying for is that, my lord, only consideration. And that consideration has been directed in quite a number of writ petitions. My learned friend will, my lord, agree to that.
But in your earlier writ petition, you have also said that it should be with retrospective effect.
Yes, my lord.
Then can you carry on agitating the same issue in subsequent writ
That has
petition?
not been, my lord, decided by this honorable court.
No, so then you should go and challenge that order and saying that the issue raised in the earlier writ petition has not been decided. Can you challenge that in subsequent writ petitions till it is till a decision is taken? Supposing this court
My lord.
does not decide the said issue, can you file another writ petition on the same issue?
No, that's
Or
not-
would you have to challenge the decision taken by this court?
No, my lord, my humble submission with your lordship is that, my lord. In the earlier writ petition, my claim was that I should be promoted and be given, my lord, retrospective effect, taking me to be a, my lord, BE equivalent degree. This honorable court has not,
No,
my
it
lord,
will-
decided the issue. This honorable court has only, my lord, said that you consider.
So why don't you go in review to the same court and say that this issue that was raised, that retrospective issue has not been decided by you. So this issue which was raised earlier should also be decided,
My lord, my humble submission is that.
or
my
you
lord,
can
if-
go in appeal
No,
and say
in
that the
order,
single
my
bench.
lord. In that order that has been passed by this honorable court, my lord, directing the disposal of the representation, it, my lord, does not suffer from any, my lord, error apparent on the face of the record. Therefore, my lord, the review application will not lie. And I also, my lord, not agree at that stage because of the, my lord, everything was a little gray at that point of time. Now, my lord, similarly situated persons have been given the benefit. What I am, my lord, praying is that my case should also be considered. They may take all these grounds, my lord. Whatever has fallen from your lordship, the authorities may take this ground. If they take it, my lord, fine, then my lord, maybe we'll take other recourse. That's why, my lord, my prayer was very limited in this petition. That since you have considered similarly situated persons, they have given you have given the benefit, consider my case also.
Who have they given?
My lord, I have annexed several orders were one order your lordship will find at page 91, 81. 81 is an order,
91.
81, my lord. Oh, I'm sorry, 91. Page 91, my lord. Process 92. Paragraph 2, here also, my lord, similarly situated person he has been given this promotion on the, my lord, regular channel without taking into consideration this, my lord, his AMI degree. Without adverting to the details of the facts, I'm reading, my lord, paragraph 2. Details of the facts involved, we take note that the petitioner was promoted from junior engineer to assistant engineer by an order dated 7/7/2022. And the same promotion order was passed pursuant to an earlier order is code dated 39/2020 in WBC 3802 of 2020. There also, my lord, direction was only to consider. The petitioner claims that he was wrongly denied promotion. His juniors were promoted by the order dated 16/9/2015. The same, my lord, order, same grievance. And accordingly, claims retrospective benefit to the promotion from the date when his juniors were promoted. For the purpose, the petitioner has submitted a representation dated 22/8/2022, which is available at annexure so and so to the petition made to the special commissioner and special secretary of the government of Assam, PWD. Without expressing any view on the merits of the claim made by the petitioner in the representation dated 22/8/2022, we require the special commissioner and special secretary of the government of Assam in the PWD roads to pass a reasoned order on the representation of the petitioner dated 22/8/2022. The reasoned order be passed within a period of 1 month. So this is the direction. And pursuant to that.
Okay, in the earlier petition, you had not taken this plea that that your juniors have been promoted. Your only plea was that you should be promoted with retrospective effect. You had not even made them parties. So can you,
I have not, I was not.
Yes, yes,
In any case, my lord. Then here also.
now
my lord,
can you keep on bettering your case? Won't all your, in a writ petition, all the questions that need to be answered, I think should have been put in the first writ petition.
Must have been pleased, my lord.
No, do you look,
In fact, my lord.
that is one issue. Otherwise, they'll keep on now tomorrow, an issue that is missed out
I'll
here.
proceed attention to another order, my lord. Pursuant to this order that we have just read, my lord, your lordship will find at page 94. My lord, that person has also been given the benefit from 2015.
No, I'm not on that. I'm on basically a different issue. When you do not take up some issue which should have been taken in the first instance,
Right.
can you keep on taking up new issues in subsequent writ petitions? Which would have been an issue and could have been an issue in the first writ petition.
I understand your lordship very much. I understand. My lord, let them, my lord, come back with this, my lord, please, because they are giving this benefit to everyone. And as I have already submitted, my lord, there was nothing to review in the earlier order. There was nothing to appeal also, my lord. And I am now promoted, my lord. Only
No, that is all right. I understand. But why didn't you make your plea that you should be promoted, but from the date the juniors were promoted in the earlier writ petition. Have you now,
I think, my lord, that is. there.
have you given up that plea, the plea that you had not raised earlier? Can it be deemed to be said that you had given up that plea?
No, my lord, it was there, paragraph 9.
What have you said? But you have not made them parties,
My lord,
not required.
not required because
Not
I'm not
required.
leaving seniority over them. I said that when they are promoted, give me also promotion. Paragraph 9 and 10, my lord, your lordship will tell you, it's there, but.
But okay, so, no, but then, if you claim to be senior to them, then they will become junior to you.
No, my case is not the seniority inter se. My case is that they were given benefit in 2015, give me that benefit.
Okay,
But
now that is very innocuous now.
yes, of course, it is.
Supposing that they give you
Yeah.
benefit as on that date, then what will be your next claim? You were senior to them, your seniority will continue.
No, my claim is not, my lord, regarding this
Then
seniority.
the
my
next
lord.
step is going to be that.
Yes.
Once they say that, once you say, because first of all, your prayer in the first writ petition was, you should be appointed, you should be promoted, promotion given.
Yes.
Now you come with the second writ petition saying that you should be given promotion as the date your juniors were promoted.
No, my lord.
Huh?
No, there lies the difference.
Okay,
The prayer maybe is that when my lord similarly situated were promoted, I should be given promotion from that. I am not claiming seniority over them. Your lordship will see in this writ petition also, in the other writ petition also.
you are not claiming seniority over them,
Over them.
only the date.
Yes, my. So naturally I will come below them, my lord.
So we'll clarify that issue, that you are not claiming seniority over those persons who have been appointed in 2000.
2015, yes, my your lordship will clarify that. And ultimately, that my lord, last document I had just wanted to bring to your lordship notice. There, my lord, the government itself has fixed it. Pursuant to the order of the honorable court, page 94, your lordship will find, my lord, the government has itself, my lord, fixed the seniority. So I am not claiming any direction from your lordship to fix seniority over someone, someplace.
Then who was appointed earlier to the post of JE?
Uh,
You or them?
No, my lord, my cases are very different.
Huh?
Perhaps, my lord, I have not been able to make myself clear to you. The person, my lord, who acquires this BE or equivalent qualification, they become eligible for consideration of promotion. That is one way of promoting under the rules. The other is that by virtue of your seniority and 8 years of experience, your case is to be considered. So, my lord, those who have completed their BE degree or AIME certificate, their cases are considered from time to time. Their cases were considered, my case was not considered. So my case in the earlier repetition was that, and even now, my lord, since I am promoted, I want to get the same benefit. So there is a difference between, my lord, asking for seniority over some other persons and fixing a seniority of, my lord, of a persons, my lord, who are similarly situated.
But I'm looking at the possibility of you filing a third writ petition and now coming
Lordship
with a
will
prayer
clarify
for
Your lordship
seniority.
may clarify that, my lord. And that question is answered by page 94, my lord. Page 94 order, my lord, my learned friends order, my lord.
Yes, second.
Yeah, because I want to know the law out here. What is it? Can we keep on coming with different issues before the single bench when one issue has been solved?
Basically,
Which issues can all have been taken up in the first instance?
No, there was some difficulty because, my lord, the question of that, my lord, Odisha lift irrigation case. What is the, my lord, implication of that order of the Honorable Supreme Court? Those, my lord, many requisitions were filed, my lord, in this case. And the first, my lord, success was in Leelamani Kumari's case in, my lord, 2017. So there are a number of litigations. In 2017, my lord, November 2017, it was settled by this honorable court, and thereafter, my lord, this type of orders are being considered and passed within the order.
Let us take this up again on some other day. Just to be sure. AMIC.
My lord, may I make a submission, my lord?
Yes,
I do not want that, my lord, your lordship should pass an order without being satisfied about the, my lord, order to be passed.
yes, yes.
If necessary, my lord, I'll bring all the other orders which are relevant for the purpose of, my lord, the satisfying your lordship on this query. Your lordship may permit that, my lord. Your lordship should be very clear before passing the order. my lord.
Correct. We'll take it up, now when,
They want to bring something on record, my lord. Additional affidavit, so fine.
My lord, perhaps on additional, if you will be my lord, helpful for your lordship to decide, I find that, my lord. Whatever.
no, it's okay. I think by this weekend I would have known.
Then, my lord, let it come on next Wednesday. Next Wednesday.
Any day, my lord. I'm always there.
This is the matter in the next week. Where is that? This petition you have taken?
I
Yeah,
have,
this is the one.
given it back.
This is the one, no?
I'll let it back.
Quite political options.
Yes,
Well, petition hearing was appointed as government governor of three revenue villages. On 28/9/2021, sorry, 2011, page 26.
so removed.
Not removed, my lord. What is the matter? While my lord rendering my service as a government governor, my lord, since 2011, but in the meantime, on 13/5/2021, my lord, I had arrested in connection with a criminal case. In the meantime, my lord, in that case, investigating officer submitted charge sheet exonerating me from the all the allegations brought against me. On that basis, I was released on bail by the Lanet Court Bill on 2/8/2021, my lord. While detaining in jail, my lord, circle officer, my lord, respondent number 4. He issued an order on 19/7/2021 asking the governor of Energy Village to look after my three revenue villages. That is page 35, my lord.
Then,
About 2 days after releasing from jail, my lord, I make an application to respondent number 4 on 4/8/2021, saying that I could not attain the duty as a government governor of three revenue villages as because I was detained in jail. Since now release on bail by the Lanet Court below, after finding no incriminating material against me in the case diary, so I will be allowed to join. Here you'll also find page 48, page 36. And my lord, get my representation. Hereafter, my lord, page 38, by communication dated 9.
you are released on bail.
My lord, bail. Release on bail, my lord. By page 38, my lord, respondent number 4 communicated my representation to the respondent number 2, saying that, my lord, he wants to continue his post, my lord, as a government governor. Necessary, maybe necessary.
Who's written this page 38?
Page 30 is petitioner, my lord.
Petitioner.
Yes.
No, page 38, lordship, it is by its
No, sorry, my lord.
circle
No, sorry, my lord. Circle officer. Circle is by communication dated, communicated my representation for it to the respondent number 2. The respondent number 4 written. To take necessary step, take into consideration all attending factors and circumstances.
Then what happened?
Then, my lord, he did not take any step, and my lord, he has not taken any steps. Then I filed under repair on the 9/5/2022 to the deputy commissioner.
Where is your suspension order? Is there any
No, no, not
suspension?
my, no, no, I'm not been suspended, no remove, not.
But why have you asked for withdrawing the suspension
My
order?
lord, that is written by petitioner, I have asked my lord, he said, no suspension. No, sir, no removal.
Then
I
what
am not,
happened?
I mean,
Then what happened next?
since 2000, my lord, after releasing from bail, I'm not allowing to join in my post, my lord. Since my lord, post of Gabura is protected under Article 311 of the Constitution of India, my lord. So before taking action against me, my lord, an inquiry should have been conducted. After affording reasonable opportunity of being heard,
Yes. Yes.
Lordship, page 26, Lordship. Page 26, Lordship, the appointment is purely temporary and may be cancelled at any point of time without assigning any reason, Lordship. It is the
Temporary appointment.
temporary appointment number.
So what is the cancellation?
Look, number two is Lordship, that this is the case where he was booked in the jail, Lordship. That is 302 under section 302. It's a serious matter, Lordship.
No doubt.
Lordship,
but,
Lordship, I'm coming to that. And Lordship, the executive instruction, Lordship, it appears that any grievances, Lordship, any grievances of the charges of the Gaungura, Lordship, it may be appeal, Lordship.
sorry, my lord, I'm coming to that.
Mr. Counsel,
yes.
that is only when there is appointment,
Yes, my lord,
dismissal, all
suspension,
that.
remove it.
Out here, there is nothing, there's no suspension, nothing.
Lordship,
There's no cancellation.
yes,
Huh?
the suspension is also there, Lordship.
No.
But now
Where
here
is
in
the
this case, Lordship, yes.
Where is the suspension order?
Yes, Lordship, here in this case, Lordship, it is, I think it is a premature case, Lordship, because Lordship, a representation was placed before the Deputy Commissioner. So far, as per his statement, Lordship, he stated that the circle officer, although the circle officer referred his application for rejoining application to the Deputy Commissioner. Now, the matter is pending before the Deputy Commissioner, Lordship.
When did it reach the deputy commissioner? The petitioner's prayer?
Page 40, Lordship, he filed this petition on 9/5/2022, Lordship.
Now more than a year, how many years?
What is the outcomes of this? We have to wait for that outcome, Lordship.
But for how long?
No, Lordship, although it is, the outcome is not before this honorable court. Whether he
You
disposed
see,
of this.
Mr. Counsel,
Yes, Lordship.
the outcome should be before him.
Yes, Lordship.
Now, because it is not before him, he has come here.
Lordship. Then we may go for that line also.
What line?
Yeah, Lordship, that we have to come. along
You are
with
not
this.
taking a decision. If you are not taking a decision, he has to come here.
No, the deputy.
So we will
commissioner-
take a decision then.
No, deputy commissioner, I have to come and along instruction from the deputy commissioner that whether that was disposed or not. Also.
Okay, you obtain instruction
Yes, Lordship.
Monday,
Yes, Lordship.
Monday, right. The grievance of the petitioner is that his temporary appointment as Ganbura has not been cancelled or suspended even till today. Though the petitioner had been released on bail in a case involving section 302 IPC, the petitioner has not been allowed to take charge of the post of Ganbura. In terms of his appointment order dated 28/9/2020.
No, sorry, 2011. I'm wrong with this, some particular mistake.
28/9/2011.
11, I can't see the original copy, 2011.
2011. Yes, sir. The further case of the petitioner is that despite the petitioner's representation to the deputy commissioner on 9/5/2022, the deputy commissioner has not taken a decision on the same till date. Mr. J.K. Goswami
Additional to the-
shall obtain instructions from the deputy commissioner concerned as to whether any decision has been taken by the deputy commissioner till date, and give a copy of the same, if any, on the next day. List the matter on Monday. Just be sure, if there is no decision by Monday, this court will dispose it of.
Lordship.
Apply.
Yes,
Lordship, the post of investigator, Lordship, in the fishery department that was created in the year 1985, along with few other posts. But inadvertently, Lordship, that post was not incorporated in the service order when it was notified in the year 1990.
what is your post?
My, Lordship, I am working as an investigator,
You're working as a investigator.
investigator.
And what is the next promotional post of
I am
investigator?
taking promotion as a research assistant.
Research assistant. So is there a post of research assistant?
Yes, sir.
Then what is your grievance?
Lordship, my,
You are a investigator.
I am an investigator, but Lordship, the post of investigator has not been incorporated in the service order. There is no
Acha,
service-
investigator is not been incorporated in the service room.
Service, Lordship.
So it is a ex-cadre post. Or what?
Lordship. Yes.
It is an ex-cadre post.
Lordship, may kindly see.
So he wants to be encadred.
Lordship, may kindly see page 52, Lordship, for one.
52.
Page 52.
Yes.
The proposal for incorporation of the post of investigator and completer in the Assam Fisheries Service Recruitment and Promotion Order 1989. With reference to the subject cited above, I have the honor to inform you that during 1985, the following posts were created under a central sector scheme for development of inland fisheries statistics by government letter number so and so dated 22/11/1985. Objective of the scheme is to facilitate implementation of program for collection of field data and coordination with method in the. Which are the posts? Deputy Director, 1 post, Investigator, 2 posts, Computer, 1, LD Assistant, 1. The other posts were Lordship incorporated in the service order, but this inadvertently, Lordship, the post of investigator was not incorporated. When the service order was notified in the.
So what is to be done?
Lordship, they may take a remedial measure, Lordship, and Lordship may forward me. Here, Lordship.
Lordship, in my submission, Lordship, this petition has not been formatted. That is required, Lordship. First, you will have to go for amendment of the order, service order, Lordship. Then encadrement of the post he is holding, Lordship.
No, that's
If
all
that
right.
is not there, Lordship, you will at least have to pay for a creation of an ex-cadre post.
Lordship may,
Creation of ex-cadre post?
Otherwise, where he will be promoted, Lordship.
You can encadre this post.
Yes, that prayer has to be there, Lordship.
What is your prayer?
Then the rejection is there, Lordship. Annexure 21.
Annexure 21, Lordship, was rejected when Lordship, I did not.
Rejection note.
Rejection note.
It has been rejected.
That is rejected in case of another statistical instance, Jugal Thakuria. Lordship. And in my case, Lordship,
Rejection of what page?
page 94. Page 94.
It is not a petition.
With reference to the subject, I am directed to inform that the matter of promotion to the post of research assistant statistics in respect of 2 contenders, namely Jugal Thakuria, statistical assistant, and Pranab Saikia, investigator, under the directive were referred to Personnel B Department for views, opinion as competent authority. The Personnel B Department rejected the case of both the contenders and informed the department by so and so. Further, as regards the repetition filed by Jugal Thakuria, the High Court order dated was of the view that relaxation can't be granted as a matter of right. That is in respect of Jugal Thakuria, your Lordship judgment is here. Your Lordship had passed an order, thereafter they rejected, thereafter he filed another writ petition. Then thereafter, Lordship, the department relaxed his qualification and he was promoted as research. But in my case, Lordship, the view was, Lordship, Lordship may kindly see page 96. The note, Lordship. So far, the case of Pranab Saikia is concerned, last paragraph, it is seen that the post of investigator is not reflected in the service order, and therefore is not a feeder post for promotion to the post of research assistant. Being so, that department may examine the scope of considering his case as promotion as prayed for and take an appropriate decision in accordance with the law. This is the approval of LRR.
Where are you reading?
Page 96 of it. Page 90. Page 96 of it, in the bottom paragraph. So far, the case of Pranab Saikia is concerned, it is seen that the post of investigator is not reflected in the service order, and therefore it is not a feeder post for promotion to the post of research. Being so, the department may examine scope of considering his case for promotion as spread for renting and appropriate pension in accordance with the law.
So you don't want to encadre this post?
Yes.
Basically,
In the service order, the post is not here.
that much to we understand. That's why he has filed the case. Now you don't want to encadre it, basically.
Lordship will listen of this not.
No, that is your case.
And this
basically.
research assistant lordship, this is 100% promotional post lordship. And as the investigator is not a feeder post lordship, so.
So he wants it to be a feeder post to
Yes,
some
lordship.
post. He wants,
And he likes, yes, lordship.
Page 95 is important, Lordship.
And earlier, lordship, there was a
Itself.
common
huh?
Personnel department itself, Lordship, opined for amendment of the service rule, Lordship. Furthermore, since the department doesn't have the service rule and is presently functioning on the,
How long have you been an investigator?
this was the
Lordship,
previous issue.
Lordship may kindly see my appointment, in terms of the advertisement.
When?
Lordship, I was appointed on 29/6/2015. And Lordship, earlier Lordship, there was a common gradation list of statistical assistant and investigator. Only Lordship to accommodate one person, Lordship, that now they have separated the gradation list in respect of statistical assistant and Lordship.
The
investigator.
statistical assistant now it is an encadred post.
Same color post, Lordship. Same skill, same skill.
I'm not on that, Mr. Council. Do you understand the question I'm asking?
This is a cadre post, Lordship.
It's a cadre post.
Is a cadre. Earlier, Lordship. there was a
Earlier, it was
common-
not a cadre post.
I'm not a cadre post.
No,
because
no.
I'm not a cadre post. That is the difficulty. Lordship.
Are you
They are not-
even listening to what I'm asking? Right, heard the petitioner's counsel who submits that the post of investigator should be a cadre post. Issue notice returnable in 4 weeks. Mr. P Nayak accepts notice on behalf of,
Respondent number 6, Lord.
respondent number 6, Mr. M Bhattacharjee accepts notice on behalf of
1 to 4 and 5 and 7 lordship.
1
1
to
to 5 and 7.
1 to 5 and 7. This is the matter of 4 weeks to enable the response council to obtain this.
Lordship, some interim protection, Lordship. Some observation, Lordship.
Next.
Lordship, pendency shall not be about to take the remedial measures to, because the service rule is being, Lordship, being finalized, Lordship.
My lord, instruction is required to be taken by us. That case is pending, is how many witnesses have been examined? There has to be the inquiry.
Item,
Item 17.
what has to be done here?
My lord, in this case, my lord, I have been appointed as a junior assistant. And
Are
I,
you filing affidavit or what?
Lordship, we have filed on affidavit, well stated in Lordship, that where it is to clear the verification. We have already submitted the verification report to himself, to him, to the office of the village Lordship. And in the report, Lordship, it is stated that he is not been linked with that incident.
so, but that has been not reflected in the affidavit, my lord.
Next, sir, Council. Yes, next, sir, B.
Who's the next year? You're an
And
next
then my-
year
in the affidavit in operation, Lordship,
of respondent number 5.
of respondent number 5. I have the honor to report that I have locally inquired,
Page
it is running page number 69, Lordship.
69. Yes,
I have the honor to report that I have locally inquired about the applicant Sri Gautam Soikia, the son of so and so, that he is an inhabitant of the village Bali Pathar of the governing since his birth. I have also consulted available PS record and found that a case was registered against the applicant so and so, and the case was suscited and the case is under trial. He is an Indian by birth. Further, I have confidentially inquired about the applicant as well as his family member here, but found no any link with extremists or outfit organization till date.
yes, so they've given a verification report. What remains?
So, my lord, then my salary may be cleared. My salary is stopped by the.
Salary be cleared by whom?
I'm asking for respondent number 4, but copy has not been served to us, lordship.
What copy?
Petition copy.
We have served earlier, we have taken steps, my lord. On the first day itself,
No, lordship.
we have taken steps, my lord.
And our name is also not reflected. lordship.
Then my I will serve my lord.
Have you got the counter affidavit?
No, lordship, as they have not served us a copy.
Counter affidavit is to be
Yes,
given by
that
him.
is also not given to us.
Okay, right. Ms. S. Kemprai, learned counsel for,
Respond number 4.
this point number 4 submits that neither has the copy of the writ petition been served upon her, nor the affidavit filed by the respondent number 5. Full stop. Accordingly, the counsels for the petitioner and the respondent number 5 shall furnish copies of the writ petition and affidavit of respondent number 5 to Ms. S. Kemprai during the course of the day.
My lord, we have taken steps 2 times, my lord. Later we have.
Is her signature there?
Yes. Yes, correct. This comes. Their communication depth is there.
Why do you give fresh copy? Leave the matter after 2 weeks.
May I please, your lordship, due to family emergency, the engaging counsel had to go to the outstation, so can it be urgent to 25th or 26th of September?
Who is the counsel who had to go out?
Suman Das. Ms. Suman Das.
Counsel for
Respondent number 2.
a genuine prayer has been made on behalf of the respondent, the counsel for the respondent number 2 on the ground of personal difficulty. Accordingly, leave this matter for 2 weeks. Next,
Your lordship,
next.
your lordship on 25th or 26th.
Please, your lord. Lord, when I am appealing for the respondents. I have already sent the affidavit for vetting, lord. Respond number
Okay, Mr.
HK, Das.
H.K. Das, learned standing
Four.
counsel, huh?
Respond number 2, 3, and 4, ma'am.
Mr. H.K. Das, learned counsel for the respondents number 2 to 4 submits that affidavit in opposition has been sent for vetting.
Yes.
He accordingly needs
And 10 days time.
10 days time to file the same. This is the matter of 10 days.
I leave. This is the disciplinary matters where the petitioner was earlier by an order.
So they've got to file affidavit.
They have to file affidavit. The matter has to be heard, my lord. It is pending because second time, my lord.
Second time. It's
Second,
a
but
very
there-
new matter. Yes, Mr.
My
Nath.
lord, they should be directed to produce the records.
Mr. D.
also my
Nath is granted how much? 4 weeks time to file affidavit in opposition.
My lord, it is Arthur.
Arthur,
My lord, let it be 2 weeks, my lord.
This is
They
the
have
matter
taken
of-
earlier time.
nothing, holidays are coming also. Nothing more.
But they have reinstated him in the post of head assistant. They are not giving the job of head assistant. Well, I'll get a date, my lord. I think I'll get a date after 4 weeks.
4 weeks should be after vacation probably.
I'll try to take a date. my lord. So what-
It'll be after vacation.
Problem.
Yes, how much time?
My lord, in this matter, I was asked to produce the records of the DPC, my lord. I have obtained.
DPC, okay.
Yes, simple matter, my lord. This is third round of litigation, my lord. He is a retired government employee, my lord. He has already retired in the year 2016.
What is this matter about?
For promotion, my lord, review DPC has been already
Only if
contacted.
his deputation is allowed, he will
Ah.
get some notional benefit only. He has already retired, but the fact
What
is
is
that,
it? What is the case about?
my lord, page 28, I have challenged the order passed by the,
Page 28,
yes, speaking order.
yes.
Well, before that, I'll narrate the fact, well, simple fact. The petitioner was initially appointed in the year 1981 as a LDA under the director.
Don't go to a
Yes.
whole history,
Yes,
just go to
yes,
the
madam.
basic.
Then in
The issue.
2015, his case was considered
For what
promotion
post?
to the post of superintendent. This is the ultimate post under the director of the health services. Then due to some clarification was sought for, his promotion was negated in the year 2015. Page 20, the first DPC proceeding. Then I approached this honorable court, page 21. Then this honorable court directed the authorities to expedite his.
What is the issue? Don't tell
Well,
me the
issue, my
history
lord,
of what.
Ultimately,
What
page
is the issue?
28.
What is the issue? Not page 20. What is the issue? Is it
Issue, my lord,
seniority? Is it promotion? What is it?
Promotion, promotion.
He
they
did not
have-
get promotion.
Yes, madam. They have
Why?
rejected my promotion on the ground that they have got 8 numbers of ACR in my favor. But out of 8 numbers of ACR, they have found only 1 ACR are complete. For that reason, my case has been rejected. I am not.
So there
respon-
was only one complete
Yes,
ACR
Yeah, out of 8.
out of it.
For that reason, I am not responsible, I am not the reporting officer, I am not maintaining officer,
But you have to initiate the ACR.
But
Yes,
ACR,
sir.
all the ACRs are written on the same date, page 28. Only to reject my case, madam.
And that too, with the adverse remarks, my lord. He was not, he was absent from duties, my lord.
That prior to that, the adverse remarks were not communicated to me.
When did the DCPC sit?
My lord, it is there in the second page, my lord. Review DPC. Yes,
DPC sat in the year 22.
review DPC, my lord.
4/11/2022.
So what does it say?
My lord, it says that, my lord, his ACR for 3 years has been 8, 9, 8 to 9, 9 to 10, 10 to 11. Were prepared in on a same date, my lord. And adverse remarks are also there. He was absent from duties and there is a criminal case pending against him, my lord. So in ACRs, my lord, that has been.
So review DPC has not recommended him for promotion. is
Yes,
it?
my lord. After considering these ACRs, my lord, they have not considered this case for promotion.
That is not my responsibility, Page 28, whereas after examining all the adverse ACRs, the committee found that all were written on the same date, 9/6/2013. But they were not communicated to the employee concerned. If the adverse remarks are not communicated, that ACRs cannot be treated as valid employees, my lord. Then, my lord, for the year 2013-14 and 14-15, the ACRs are not complete. Who is responsible, my lord, for not completing the ACR? In earlier round of litigation, they have found all the ACRs to be complete. Page 23, and I was recommended, but even recommendation, I was not promoted. Page 23,
Just a minute.
page 22, once I was considered.
Just a minute.
Yes.
Okay, so now the issue is only those communicated remarks in the ACR, those communicated ACR gradings can be considered by the DPC. Now, what is the ACR gradings for which year were considered by the DPC?
From 2008,
2 2008, 9,
9, 10,
9, 10,
10, 11,
10, 11,
11, 12,
11, 12,
12,
13, 12, 13, 5,
5.
12, 13.
There are some advanced remarks that were not communicated to me.
Which
There-
one? Which ones were not communicated?
These 5 years ACRs.
Which ones out of them?
All of them
got the.
Then
All of them were not communicated.
yes.
So
Then-
all of them, let it be communicated, in terms of Devdutt's case.
My lord, next, my
Let
lord,
it be communicated and let the decision be taken on the representation by an authority higher than the person who made the remark.
Yes, my lord.
my lord, next, my lord, 2013, 14 and.
No, how does it matter 2013, 14? Which ACRs have to be considered?
My-
You
5
see, it
years.
is
5 years,
5 years,
Yes.
but in which year? When did the DPC say?
2015, 16, 1 year. From
Mr.
2012 to 2016.
You're not listening, please listen. Okay, if you don't listen, I won't listen to you.
2015, I should be considered. But prior to that, 5 years.
Mr. Counsel, please let me speak.
Yes.
List the matter after 2 weeks.
Let
I'm
me-
going to give an order, but you're not listening at
No,
all.
my lord, sorry, my lord.
Next,
Sorry, my lord, matter may be disposed of today.
after 2 weeks. Huh?
They have filed affidavit in the matter.
Okay.
Government will take need.
Mr. B.T. Das Leonard, Senior Counsel, is granted 2 weeks time to obtain instructions with regard to the affidavit in position filed by, you file
Yes, lordship, respondent number
file-
2 has filed.
filed by the respondent number 2. So the same, however, is not on record. Registry to pay the same on record. That is the matter after 2 weeks. Yeah.
My lord, I take your lordship, my lord, this order passed by this page 44, my lord, can you see?
Yeah. This order is wrong.
Yes.
Huh? How can the executive engineer
Yes, lord.
regularize the service of the, of your service without, against the, against the non-existent post? It's not even made personal to him.
My lord, then I take your lordship, page 43, my lord. Page 43.
Yes. No, you see, pension is a different issue. Pension will come only if you are a regular employee. Now, to be a regular employee, you have, your service has to be regularized
Yes,
against some post. Now, the page 44 indicates that the executive engineer had regularized your service against a non-existent post. How can that be?
I am also in similarly situated position, my lord. You see, my lord, kindly,
No, it is you. It is, so this, executive engineer, Karimganj division, how can he regularize you as a helper for the purpose of pensionary benefits? Unless you are regularized against some posts which may be made personal to you or any substantive regular post. How can?
that is very
cannot be
true.
done. Then, so then what to do? So this executive engineer's document, yes, I think it is. This is irrigation. This is irrigation, not this. In pursuance of the.
There are 22.
This is with regard to the minimum pay scale. No, but whatever order is order, whether it's correct, it's a valid order.
This ordering was applicable from 2017. Even these orders could not have been passed. But in terms of these orders, person has been regularized. Well, there was no order for regularization. It was only for the purpose of payment of
The problem lies. Look, page 29 now, unless there is a challenge to this order has, it remains that as it's. Now, I cannot make a comment on that. Now, with regard to the order passed by the executive engineer, regularizing the petitioner. Now, this order is still a valid order. Is a valid order unless and until you cancel the order or you nullify your order or the court says that it is without jurisdiction or it is set aside. But then that has to be put to challenge. Till it is put to challenge, it remains a valid order. So that is the predicament of this court. So we'll have to, yes.
It is why Lordship, page 44, Lordship, the AG has returned the file, Lordship, Lordship penalty paid paragraph, Lordship. Therefore, creation of supernumerary post of grade 4 for regularization of service is required with approval of finance department. Without the finance department approval, Lordship, the executive engineer
I
has
am
no
not,
power.
you see, Mr. Counsel, you are jumping the gun. The issue is with page 34. Page 34 does not seem to be a proper order. Be that as it may, it is still an order.
No.
And as per Supreme Court judgments, an order passed by an administrative authority, so long as it is not cancelled or modified by the competent authority or set aside by the court, it is a valid order. So, if it is a valid order, you have to act upon it. Unless you correct this order, you have to correct this order. Unless you correct this order, then because his prayer is only for minimum pay scale as per the order. Now, court also has given him minimum pay scale, but you have given you have regularized. So that is your mistake.
Lordship,
But it is your order.
this is the wrong order, Lordship.
So
Absolutely.
you correct, because it is very difficult for this court also to pass a reasoned order
Yes.
in the with all these anomalies.
I will fight.
Mr. Biswas,
I'll
what to
leave
do?
it to your Lordship.
Yes.
I know what is the limitation of my case, my lord. But since it is regular, that's why I approve. And I have submitted, they have asked me to deposit the paper. I have submitted all the pensionary benefit paper.
You're very lucky you've got this kind of order.
But I become unlucky and nothing else. There is no progress of the
They
order.
cannot be because I will be perpetuating an illegality.
Very true, I know that.
Right. On the prayer form, the prayer made by Mr. N. Upadhyay. What is the matter after? 4 weeks. 4 weeks.
No.
You make a correction.
May I please? So in this
Yes.
case, we are praying for consideration of our prayer for review. Here we are yet to file a affidavit, my lord.
Okay, Mr. R. Dhar is granted 4 weeks time to
Okay,
file
the
affidavit
last
of
two-
position.
last-
Leave the matter after 4 weeks.
Last two occasion they have.
Huh?
Last two occasion also they have.
It's a
23 matter,
23
Mr.
matter, my lord.
Counsel. Yes, how much time? What is this matter about?
This is regarding compensation appointment. Already the clause 1 of OM dated 1/6/2015 has been struck down by the covered case, my lord. Now today, my learned friend is saying,
Show me that striking down that judgment.
yes, I have. I'm bringing my, I'm sorry.
Okay, so what to do?
Lordship, this is an old pending one, Lordship, and it has already been considered, Lordship.
No, but rejected on what ground by the SLC?
Lordship, due to want of vacancy, Lordship.
Due to want of vacancy?
Yes, Lordship.
Is it due to want of vacancy?
No.
Let us see SLC meeting minus. That was interfered with by the order dated 24/6/22. Clause 15 of OM has to be applied.
Yeah.
That's what the court has held.
But Lordship, whether 2015 will be applicable
This
in
is-
this case.
The order of this court is here.
Yes.
The thing is, whether it's applicable or not. That too, I cannot, this court cannot go into that because in the order dated 24/6/22, passed in WPC 4220 of 22,
Lordship.
it has been said that this clause should be applied. Where is the subsequent order of the High Court?
Lordship will find at page 43 and relevant portion 44, Lordship. Page 44. Serial number 4.
43, 44 is
What? 44 is relevant,
speaking order.
speaking order.
No, that's speaking order.
The SLC is speaking order.
Where is the petitioner's name?
Petitioner Noyan Jyoti Bora. Lordship will find in the last column.
Okay, so, yeah, he has to follow. You see, what has happened is,
Lordship.
court has said in page 29, 28, 29,
Lordship.
that that clause 15 of the OM should be applied. Should be considered.
Lordship.
However, the SLC has rejected the petitioner's case on the ground that the deceased government
That's a
servant had
3-year
attended
service.
the- Now, that has been set aside already.
Lordship.
And in any event, the direction of this court was to apply clause 15.
Lordship.
Only problem is, Mr. Counsel,
Because the vacancy will be for that period only, Lordship.
the
No, like. Here only the.
Vacancy cannot be sufficient, Lordship.
the clause 15 would have to be applied by the DLC, not by the SLC.
SLC.
So
Even,
that will clarify.
even, my lord, in other cases also, my lord, the already SLG has considered under, under the clause 15 of the
Okay,
OM.
okay.
I have found lot of cases, my lord, I have.
Give me one.
Lordship, shall I bring? Can it be taken up day after tomorrow, Lordship? No? I shall also go through this, Lordship.
I
On
have-
Friday, Lordship.
I can produce.
Heard Mr. B. Chedri, learned counsel for the petitioner who submits that in terms of the order dated 24/6/22 passed in WPC 4220/2022. The petitioner's case, the petitioner's application for compassionate appointment was to be considered in terms of clause 15 of the OM dated 1/6/2015. Full stop. However, the state level committee in its, where is that? Impugn 40,
44 Lordship,
in its,
44 page.
in its speaking, is it speaking or no? However,
Yes, SLC is speaking of.
no, it doesn't say that.
Lordship, 44, it says this is government employee had less than 3 years of
No,
service.
no, where does it say SLC?
SLC, this is the SLC matter.
Where does it say SLC? It doesn't say SLC.
Animal husbandry, censure.
However, in pursuance to the SLC meeting minutes. Meeting held on 18/9/22.
Then SLC,
18/9/22.
yes,
The
page 32 Lordship, SLC.
application for compassionate appointment made by the petitioner had been rejected on the ground that the petitioner's father, Rameshwar Bora, who was working as an accountant in the office of the Joint Director, AH and Vetting Department in Upper Assam Zone, had less than 3 years of service at the time of his death, that is on 29/10/2011. So stop. Next paragraph. The rejection of the petitioner's application for compassionate appointment by the SLC does not seem to be proper and is in violation of the order dated 24/6/2022 passed in WPC 4220/2022, inasmuch as while the said order dated 24/6/2022, the petitioner's case was to be considered in terms of clause 15 of the OM dated 1/6/2015. Next paragraph. The rejection of the petitioner's case on the ground that the petitioner's father had less than 3 years of service at the time of his death is in terms of clause 1 of the OM dated 1/6/2015. Which has been. Where is that order?
Here is out.
Page number.
1/6.
Page number.
Which para? Which para?
Behra Lordship.
which has been held to be unconstitutional and violative of Article 14 of the Constitution in the judgment and order dated 30/01/2023, passed in WPC 1646/2021 and 7947/2019. Then what is to be done?
Lordship on Friday, Lord.
Since
No, who will decide whether the SLC will, huh?
SLC.
Where is the order?
Well, at that, not today.
The question is whether the DLC or the SLC will decide the application of clause 1, the application of clause 15 of the OM dated 1/6/2015. The councils for the parties shall make their submissions on this score on Friday. This is the matter of fact.
How much your lordship?
Lordship, here in this case, Lordship,
Let's the compassionate.
Huh?
Compassionate appointment.
Lordship, affidavit is ready, Lordship. It is
What
sent
is the, why compassionate appointment? What happened?
Petitioner father voluntary retired, your lordship,
What did you retire?
retired on medical grounds. Your lordship. He is covered under office memorandum 1/6/2015.
What did you retire when?
On 2009.
2009.
Uh,
And DLC approved,
no, your lordship, what happens, petitioner
DLC rejected.
is rejected.
When?
Page 31 metal.
When?
On to,
On?
as per, it was communicated by the letter, no minors has been furnished to the your lordship.
No minute. Where is that letter?
Letter is on page 31, page 31, annexed to it. And ground has not been mentioned in the letter.
2012. Okay, right, Mr. J.K. Goswami, learned counsel for the respondents, submits that affidavit in opposition is ready and will be filed within,
next week, Lordship.
will be filed, why not this week?
Next week today, next week.
Will be filed within a week. In a week. This matter thereafter.
Yeah, please, your lordship. I thought I need 2 weeks time to file the affidavit in reply to the affidavit in opposition.
Lordship, it's a transfer case and stay is there, Lordship, and I filed my affidavit 2 months back, Lordship.
You filed an affidavit?
Yes,
Oh,
I have to file the reply because I have received the Paravas comment from my client, my lord. So 2 weeks time may be granted, my lord, we will file it, my lord, because I have to annex certain documents.
what documents?
My lord, regarding the transfer, my lord, the place of choice, because this transfer which was been given is when my representation was under the authority and he tried to influence the authority that my representation should not be considered. So on the basis of that, your lordship has passed the order and state the transfer because I am a disabled person. and with a artificial leg. So I need the medical attendance every week. So these are the question, my lord, which I'll place, and I will place, my lord, one act, my lord, of 17. We said that if there is no post, then he should be kept in the supernumerary post till his service is retired. My lord. Those things are there, my lord. That's why I need, my lord, to bring on record all those documents, my lord. So 2 weeks time, my lord, within 2 weeks, I'll file it, my lord, and then the matter can be.
When did you file your affidavit?
18/7.
18/7,
Yes, Lordship.
8/9. 2 months have passed, Mr. Council.
Yes, my lord, I agree, my lord. He has given the affidavit, my lord, very recently, so I have to prepare.
When?
it. My lord, he has given me the parawise comment just 15 days back, my lord,
No, no.
because he was under the treatment. So he came with this and has given to
Who
me.
is this Miss B. Talukdar?
She. Oh, no, B. Talukdar is my junior. my lord.
Your junior?
Yes.
Her,
She's-
her signature
Yes, yes,
shows
I,
that she received it on 19/7.
19, I accept, my lord, because
Ah,
my client has,
not 15 days back.
no, my
19/7.
client has given me the parawise comment, my lord. Okay.
Your client is giving you parawise.
Yes,
Okay.
he has given me because he is working there, you are the treatment, my lord. So I'm praying for only 2 weeks time, my lord. It will be filed by.
Okay. Mister?
He will check.
Huh?
He will
Put a charge, learned counsel for the petitioner. Submits that. And affidavit in reply will be filed within 2 weeks. Accordingly, let this matter after 2 weeks.
Again, because
Give a date.
can we be on 6 Lordship, on 4 Lordship?
Four.
Okay, obliged.
Other cases will be disposed of by setting aside the order of termination. So this, I'm complexing for the same.
Facts are a bit different in this case.
One of the petitioner was working as Sahaya since 2009. And there was a PIL. PIL order, your lordship will visit is 35.
No. So what is to be done here?
My lord, in this particular case, the case of the petitioner is that there has been a violation of natural justice. We have given him a copy of the inquiry report. We have sought for his stand before finalizing the inquiry report. at every
Contractual
stage.
employee.
Yes, contractual employee.
Well, all contractual employees, your lordship will visit, they were terminated and it was order of termination was set.
Yesterday only, my lord had disposed of a similar matter wherein my lord had observed that since a copy of the inquiry report was not furnished to the contractual employee, so let the inquiry be restarted once again, de novo. But in his case, the inquiry report has been given to him, furnished to him, and in fact, his stand was also sought for during the time the preliminary inquiry was ongoing. In fact, I'll take my.
No, so what do you want to show here?
And similar persons, my lord, they filed petition before this honorable court. This honorable court set aside the order of termination. If they are saying that the stand of the petitioner is different, they stand at a different footing, they will have to file affidavit. Otherwise, this petition can be disposed of. This is what my stand is. And
So you
if
find
they
an
say-
affidavit?
Let them file their affidavit.
Mr. S. Datta,
Be handling, my lord,
Mr. B. Handy,
on behalf of Cake More,
on behalf of Mr. K. Kumar, learned counsel for
PNRD,
PNRD department. Is granted
4 weeks time. my lord.
4 weeks time.
Interim order will continue.
4 weeks time to file affidavit in opposition. This is the matter of the 4 weeks.
But the interim order will continue.
Interim order to continue till the next. You
But
file
this-
it
but like-
because the now out here, it's a question of fact. If you can show that it has been given to him.
My lord, I can take my lord through, it's there annexed in his writ petition. I'll just
Oh,
take you- Yeah, it is all there. Everything is there, my lord. It's
Okay.
crystal clear.
But in that case,
But
let
let
them
me
file
see.
affidavit, my lord.
No, if the facts are here,
Facts are here, my
so
lord.
what's the requirement?
The order that was passed is at page 35 to 36, my lord.
35
Order
to-
passed in a PIL.
Yeah,
operative
in
part
that
is
case,
that
let me submit my petition, my lord. I'll show that what they given.
No, no, I just want to see that the inquiry has been furnished to him. That's
No, no, that is the page at page 54, man.
page 36, my lord.
Page
The-
54, man. This is the show cause notice given.
So as my lord, the court, the honorable division bench has directed the DC to dispose of the representation, which is at page 36. The enquiry, and pursuant to that, his stand was sought, which is at page 37. So once he gave his stand to the PNRD department, the enquiry report was published, which is at page 41. And subsequently, a show cause notice was issued, which is at page 54. The copy of the enquiry report was furnished to him along with that show cause notice, page 54.
okay. So where is his reply?
Pursuant to the show cause notice, my lord, his reply is at page 55.
How much has been misappropriated? It's in the inquiry report.
Inquiry report is at page 41, my lord.
Okay.
So it was like scheme, there were a couple of schemes, my lord. So in every scheme, there was misappropriation of funds. So all total, there were 1, 2, 3.
But where does the inquiry report blame him?
Not pursuant to the order of the division bench, his comments were sought from at page 37.
No, my query is, where is the finding in the inquiry that he had misappropriated money?
Specific findings to that effect. Under that particular instruction, I'll have to take into consent.
Okay, whatever I said. Mr.
P. Handick.
B. Handik, appearing for Mr. K. Kaur, learned counsel for the PNRD department, is granted 4 weeks time to file affidavit in position. This is the matter after 4 weeks, interim order to continue till the next week.
Lordship, hearing this matter, I have filed my affidavit, Lordship, today, Lordship. The same
Lordship,
is not on record, Lordship.
they have, I had got two prayers, my lord. One, they have complied with by constituting State Allied and Healthcare Council, your lordship, which is constituted on 28/4/2023. My other prayer was to interim registration of my name, since I am a allied healthcare professional and I have already prepared an application before the authorities concerned. So lordship, in that event of the matter, since they have filed an affidavit that the council has been constituted, my name be registered, your lordship.
So wait, so the State Allied Healthcare Council has been constituted
Constituted on 28/4/2023.
28.
4/2023, your lordship. and they have
28/4/23.
affidavit.
So,
Affidavit.
so that part is been done.
Yes, complied.
Now, the only requirement is to consider your claim
Yes,
for registration.
yes, your lordship. Under section, section 38. of the National Commission for Allied and Healthcare Professions, that 2021.
But that is, okay, so let them consider
Yes.
what,
Lordship, let it come on record, Lordship, the affidavit.
Lordship,
what affidavit.
that affidavit which they have filed today.
Today, Lordship.
It will come on record, but it is there.
That is my copy I have given to the Lordship.
Hmm.
No, Lordship, that affidavit was cancelled, the previous one. Lordship.
Previous one was cancelled.
Okay, previous.
Subsequently, today they have
Today-
filed one.
It come on
So,
record.
so have you filed it?
Yes, Lordship.
Yes, that
Then we'll-
copy I have.
it'll
filed
come.
to your Lordship.
It'll come in the record. Now, so what do you want?
Lordship, Lordship can give a direction to consider, Lordship.
That's all, the direction to consider, that's all. If it is not, if it's not, allowed, then she can always come, that's all. So you have not stated anything with regard to her
My
application.
marriage thing.
Okay, right. Heard Miss B. Buyan, learned senior counsel appearing for the petitioner, as well as Mr. D. Upamani, learned standing counsel for the
Health and Family Welfare.
Health and Family
Lordship,
Welfare
dear Lordship,
Department.
Medical Education and Research Department.
Huh?
Medical Education and Research Department
For the Medical Education and Health
and Research Department.
and
Research,
Research Department. You got it?
MER.
First up. The petitioner has sought for a direction to be issued to the respondents to constitute the State Allied and Healthcare Council as required under Section 22 of the National Commission for Allied and Healthcare Professionals Act, 2021. First up. The further prayer of the petitioner is that the petitioner had submitted an application dated 24/1/22 for provisional registration under Section 38 of the said Act. First up, however, the same has not been decided till date. First up. The Mr. D. Upamani has submitted an affidavit in opposition dated affidavit filed by the respondent number 3 on
Today, your Lordship.
29.
today. That is 20/09/2023. Which states, where is that?
They have annexed, my lord.
Where?
Notification dated 28/4/2023.
121, Lordship.
Page,
121. Annexure 3.
which shows that in exercise of the power conferred upon the state government under Section 22 of the National Commission for Allied and Healthcare Professions, bracket NHCAHP, bracket close Act, 2021. The Governor of Assam has been pleased to constitute the Assam Allied and Healthcare Council. In next paragraph, in view of the above. The only question that remains is with regard to the application made by the petitioner for provisional registration under the said act,
The section 13.
under section,
38.
under section 38 of the said act. Pusta. The respondents, no, on considering that the State Allied and Healthcare Council has been constituted, comma, the said council is directed to consider the petitioner's application under section 38 for provisional registration within a period of 1 month
My lord.
from the date of receipt of a certified copy of this order. Let it petition accordingly.
Can I get back my affidavit, which was certainly?
Why?
I'll give a copy to your lordship.
I'll give a copy to the lordship.
It's okay.
All right.
Obliged, sir.
The petition is allowed, my lord. Allowed.
Okay, the writ petition is accordingly allowed.
Okay.
May I please?
Yes.
This case, I'm appearing for the respondent number one, madam.
Yes,
And this senior counsel, Mr. Yukana has some difficulty.
item 31.
It's a review petition, my lord. So otherwise, the issue is very limited, and it's very short issue. The matter has been listed a couple of times.
That poop, again, that poop thing, no,
That poop thing, my lord.
that same thing.
The entire issue is with regard to the names, my lord. Some confusion has arisen because of the name. So, my lord, I intend,
Why don't you all come together?
I'm always there, my lord.
Where is your counsel?
My lord, some difficulty just now inform me, my lord, over time.
Please, on the prayer made on behalf of Mr. Yukana, by the senior counsel, list the matter in the next week.
Thanks.
My lord, can it be on a hearing day kindly, my lord, because otherwise it is listed for orders, my lord. So it's always listed at the tag end of the court.
List the
Tuesday
matter
or Thursday, my lord, there's no
on. This is the matter on 26.
26. I'm very grateful for that.
What to do? The counsels for the petitioners have withdrawn from the case. And they have been struck off. Now notice will have to go. Right. In terms of the order dated 28/08/23. The counsels for the petitioner have withdrawn from the case. And their names have accordingly been struck off from the cause list. Registry to issue notice to the petitioner, informing him that there is no counsel to represent him in view of the above fact. In view of the fact that his counsels have withdrawn from the case. This is the matter after 4 weeks.
Matter pertaining to non-payment of retirement benefit, my lordship.
Non-payment of
Retirement benefit, my lordship.
leave encashment and gratuity. Yes,
No, my lord, may it please, your lordship. Now, what will happen, my lord, the sole respondent has been transferred, my lord. So
He's been transferred.
He has been
So
transferred.
who has taken his place?
Now, one Jitu Mani Talukdar has taken that. Let them do it.
Jitu Mani Talukdar, what is he? He's the managing director now.
Yes.
What to do?
Lordship, I will file a representation before
You file an application for amendment. What?
for improvement.
Improvement.
Yes.
Okay, right. Mr.
AB.
Huh?
AB. AB.
A Day. DY. Mr. A Day, Learned Counsel for the respondent submits that the respondent has been transferred out and the new incumbent to the post of managing director is Mr.
Jitu Mani Talukdar.
Jitu Moni Talukdar. So, sir, the petitioner's counsel submits that he will be filing an application for improvement of the new incumbent. Accordingly, leave this matter after.
Lordship, I have a small prayer, my Lordship. 12 number of contempt petitions,
Huh?
similarly situated. 12 number
Yes.
of number 145 of 2022. So I pray that this may be also tagged along with that one.
Accordingly, list this matter after 2 weeks, along with double contempt case number
145 of 2022.
145 of 22. What is this document? Okay, put it there.
Order has been complied with.
Complied with.
Your Lordship, actually, what is in petitioner, after completion, compliance of the orders, after 4 days, Lordship, one person from among the promotees retired. So I have filed petitioner number 4, since he is the next promotee, so he filed a representation before the authorities do got promotion, Lordship. And Lordship, the representation has not been considered till today. So Lordship, I maybe
Mr.
get liberty to
Madam,
file a
Madam, this is a contempt case. The only thing that this court will see is whether the order passed in the writ petition had been complied with or not.
Yes,
Wait.
Lordship, but I may be file a liberty to get file a refresh rate, Lordship. Petitioner
You
number
do
4.
anything, no observations can be made in a
Okay,
contempt,
Lordship.
right? Miss
K. Pujari, Lordship.
K. Pujari, Learned Counsel for the petitioners,
Yes, Lordship.
and Mr. D. Bora. S. Bora, Learned Counsel for
All the respondents.
Number 1 and 2.
correspondence number 1 and 2. Submits that the order dated 9/11/2021 passed in WPC number 518 of 2021 has been complied with. So accordingly, the contempt petition stands closed.
Obliged, Lordship.
Lordship, in this case, the petitioner have been granted interim protection, Lordship.
So?
Lordship, and notice was issued to the respondents, Lordship, on the
Huh?
last. And notice was issued to the respondents by the order dated 26/2022, Lordship.
Yes, who is appearing?
So far, my instruction is concerned, my lord. BTC is here to take a final decision because, my lord, the authority has written a letter to the senior selling council, the BTC, for his opinion, my lord. So sometimes maybe granted. Otherwise, also, my lord, stay order is there. The petitioners are in their office.
So. Mr.
Yes, sir.
S. R. Rabha
Any council BTC.
appearing for the respondent number
my lord, 4, 5. 4 and 5.
Appearing for point number 4 and 5. Submits that he needs some further instruction. Submits that he needs instructions as the BTC are considering the issue. Is it?
Yes, Lord.
Then who else appears?
I'm appearing for 1 and 3.
Mr. Yes, that appears for point number 1 and 3. What about 2? Finance?
5 and 4.
While Miss M. Bhattacharya appears for point number 6. Then this matter after
My lord, 3 weeks.
3 weeks.
Lordship, the interim is still further ordered.
There is any interim?
Lordship, there was an interim.
Interim order to continue till the next week. What is the matter about?
Lordship, contempt.
Where is the order?
Your lordship, order annexer F lordship, page number 26.
Yes.
Lordship, non-compliance of the said order, lordship, I have filed representation before the authority, annexer D lordship, page number 29, your lordship. For that motion, lordship.
Why contempt? Mr. Council, the SLC is headed by the chief secretary.
Yes, Lord. My
Then-
appointment was not made out. Not to
You have not given any letter to the SLC
Yes, Lord,
or
I
to the
have,
chief secretary. Where?
lordship. I have sent it to the state level committee, Lord,
Where?
represented by Commissioner and Secretary, Lordship.
Where?
In
Where?
my representation, Lordship, Annexer G, page number 29, relevant points on page number 30, Lordship, I have mentioned here,
29
Lordship.
is addressed to the DLC.
Lordship,
DLC.
copy sent to state level committee represented by
Copy is
Commissioner and
different thing.
Secretary.
Copy is to the state level represented by commissioner.
Yes.
If the chairman is the chief secretary, Mr. Council, how do you know that the commissioner secretary will be there? Who constitutes the SLC?
But Lordship, in the specific direction, Lordship, thus Lordship, I was directed by this court, Lordship,
Hmm.
that Lordship, relevant portion 27 kindly be perused, Lordship. That considering the relief paid for this petition is disposed of directing the respondent number 3 DLC to immediately place the case of the petitioner along with other similarly situated person before the next immediate sitting of SLC for consideration. Thereafter, SLC shall communicate to outcome of the consideration to the petitioner. Therefore, Lordship, my proposal has been forwarded, Lordship, by the district level committee, Lordship, Annexer 8, page number 31, Lordship. So my proposal has been sent to the Secretary of the Government of Assam, Lordship. That is Annexure H, page number 31 law. My proposal has been forwarded along with the Honorable High Court order, Lordship.
So we'll issue notice only to the DN, to the deputy commissioner, that's all. Because only the deputy commissioner has been given a direction. Right. The petitioner's case is that the order dated 21/11/22 passed in WPC 7348/22. Directing the district level committee represented by the deputy commissioner Lakhimpur to place the case of the petitioner before the next sitting of the SLC for consideration of the petitioner's application for compassionate appointment. So the petitioner had given letters to the deputy commissioner Lakhimpur on 28/11/22. There is nothing to show that the SFC has been made aware of the petitioner's application for compassionate appointment. Nor the recommendation made by the DLC. Accordingly, issue notice only to the respondent number 3. Petitioner takes steps for service of notice upon the respondent number 3 only via registered post with AD within 3 days. Miss the matter after 4 weeks.
Deeply obliged.
Lordship, second round of litigation before your lordships. If I may just place the brief facts of the matter before your lordships, what had happened was that the petitioner's husband had acquired a disability while he was rendering his services as an executive engineer before the PHE department, your lordships. Now, as per the Right of Person with Disabilities Act, if a person who is in service acquires a disability, therefore he cannot be removed from his post in case he is unable to perform as per the duties which are allocated to him. A supernumerary post is required to be created, and he has to be given the same salary and payments which are required to be paid to a normal service employee. This is as per the Rights of Person with Disabilities Act, Section 20, Clause 4. Your Lordships. Now, in the first round of litigation, we came before this court praying that his salary and his emoluments should be released to him. There was a specific order passed by this honorable court saying that you assess his disability. The direction was given to them that you can constitute a medical board, assess his disability, and thereafter release the dues which are entitled to him in terms of Section 24 of the Act. Now, there was a specific direction to that effect. They, subsequent to such directions, when I placed these orders before them, what they did was they held a medical board. They assessed my disability and said, yes, he is 100% disabled. But instead of releasing my salaries and my emoluments, what they have done is they have issued an impugned order, your lordships, which is at the last page of the writ petition, which is the second round of litigation before your lordships. Now they have categorized me as a person who will be granted invalid pension in terms of the old law which was prevailing prior to this Rights of Persons with Disabilities Act has come into force. There's a specific, it is no longer reintegra, your lordships. When a specific law is brought in, it has to prevail over the general law. This is the normal fact of the situation. Therefore, in abundant caution, I had also filed a contempt petition because they had not complied with the earlier order, which is item number 41 before your lordships. In item number 42, they are yet to file their response till date. And lordships, I am in a very bad situation because my husband he was the main bread earner of the family. I am the legally married wife, and I have no way of looking after his health and services. That is where the matter stands. as of date.
As far as arrears salary is concerned, the department completely sympathize with the petitioner lordship. I have specific instruction that since there is some procedure for drawing of salaries, the lordship is well aware that the petitioner is 100% disabled, so he cannot put
How long
signature
hasn't he been paid?
from
Lordships from March two
from
thousand
2023.
19, March 2019, Lordships. Interminably,
2019.
2019, Lordships.
So now
Interminably, may I just place that interminably some amount was released to him earlier before the first round of litigation. Thereafter, nothing has been released, your lordships. And they keep saying that they're sympathetic to me, lordship. The problem is that my husband is 100% disabled, not just physically, but also mentally. There was a major hemorrhage in his head, and he has acquired cognitive disabilities, your lordship. So the fact that they ask him to sign on a paper will not help because he cannot sign.
in that case, your lordship, I've taken instruction, lordship, if the petitioner approaches the authority as a legal guardianship and signs on his behalf of the person, the department will release the salary, your lordship.
Lordship,
They will release the salary.
in that case, this petition can be disposed of because I have already applied for legal guardianship of my husband. And that order has also been passed. I'm just placing this before your lordship. In the meanwhile, I had applied for legal guardianship because for all his other areas, I will be required to be made a legal guardian, your lordship. I had applied duly. Lordships, I apologize for the this thing. I got the certificate today morning by way of a PDF. Hence the slightly illegible.
What is the name of the wife?
Bonojotsna Das, lordship, the petitioner before your lordships.
So let us see the order dated 9/2020.
Lordship. Lordship will turn to page. Government order to. In the writ petition, your lordships.
Page number 89, your lordships.
Contact.
Repetition.
Writ petition for 90.
Oh, 90.
Page 90, lordship, the effective portion is at annexure 17, page 89 of the writ petition. I will read from page 91, your lordships. Circular particle working in there. It had the circular actually not permitted. Because I think. Can you circular as well? What is it?
So this appropriate order for salary has not been passed.
Yes, your lordship.
However, as on date, we have received oral instruction
Yes, your lordship.
that if she has a guardianship certificate, she can take the salary
Yes,
and
sir.
other allowances on behalf of her husband.
Because he cannot move at all, the
So
lordship.
we can close the entire
Lordships, the only, my only consideration is or grievance is that they should comply with the direction. That is my only grievance. In the first round of litigation also,
they did not.
a specific direction was issued. Instead, they issued the impugned order saying that some vague department, some ARTPPG, I have never even heard of this department, your lordships. This department says he's entitled to invalid pension and therefore she should not be given the normal salary. Now, lordships, I am being made to run from pillar to post. That is the only grievance, your lordships.
What is this second writ petition about?
challenging that order, Your Lordships, that they have,
In the-
instead of complying with the directions, they issued the impugned order, which is the impugned order.
Which
Your
is the,
Lordship,
which
in
is the impugned order?
last page of the writ petition, Your Lordships. Page 111, annexure 28, the last page. Your Lordships.
111.
Yes, Your Lordships. This is the department is Administrative Reforms, Training, Pension and Public Grievance Department, Your Lordships. Now, if I will just read this letter, references endorsement of the Secretary to the Government of Assam, ART PPG Department dated 1/11/2022. With reference to the letters on the subject cited above, I am directed to inform you that the Secretary to the Government of Assam, ART PPG Department has advised to act as per Rule 82 of the Assam Services Pension Rules 1969 for sanction of invalid pension to Shri Kamal Das, which is my husband, Your Lordships. Therefore, you are requested kindly to take necessary action to prepare proposal for sanctioning invalid pension in respect of Shri Kamal Das at an early date as per rule and as admissible. Now, the secretary, whoever this gentleman is, this ART PPG department is perhaps unaware of the law that there is a specific direction, there's a specific law which prevails in the country called the Rights of Persons with Disabilities Act. And in fact, Your Lordship, there is a notification of the government of Assam itself.
No, but then the question is, supposing you cannot work, then what happens?
That is what section 24 says. If I may just take Your Lordships to section 24 of the RPD Act, Your Lordships. I have quoted that section in the petition itself. If Your Lordships will just take it up for a moment. Lordships, page petition of 38 maybe. 29, I'm going, Your Lordships, 29. Yes, Your Lordships, page 29 of the writ petition, paragraph 38. I have quoted the provisions of section 24, Your Lordships. The petitioner humbly begs to submit the section 24 of this Rights of Persons with Disabilities Act states clearly as under. No government establishment shall dispense with or reduce in rank an employee who acquires a disability during his or her service, provided that if an employee after acquiring disability is not suitable for the post he was holding, shall be shifted to some other post with the same pay scale and service benefits, provided further that if it is not possible to adjust the employee against any post, he may be kept on a supernumerary post until a suitable post is available or he attains the age of superannuation, whichever is earlier. So it is very clear, Your Lordship. The law is very clear. In fact, like I was just telling Your Lordship, there is a Government of Assam notification specifying that the provisions of section 24 ought to be complied with by all departments. I'm just placing by that particular notification before Your Lordships. This is of 6th of January 2020. Unfortunately, out of copy, sorry, no, I think Lordship, this unfortunately I could not lay my hands on this notification prior to filing of the writ petition. I'm placing before Your Lordships. This is a communication by the Additional Chief Secretary of the Government of Assam Social Welfare Department to the Principal Secretary and Commissioner of Secretary of all departments, Your Lordships. With reference to the subject cited above, as you are probably aware, that the Central Act, the Rights of Persons with Disabilities Act 2016, was enacted in 2016 and it came into force with effect from 19th April 2017. Accordingly, both the central as well as the state governments have been mandated to take necessary steps for the implementation of the various provisions under the different sections of the Act. The Social Welfare Department, as the main stakeholder department in respect of disability matters, is coordinating and facilitating the implementation of the RPWD Act 2016 by the different government departments. Then they quote that section which I just read, Your Lordships, section 20. The Honorable Supreme, next page, Your Lordships. In the light of the provisions, second paragraph, in the light of the provisions specifically laid down in section 20 and section 28 of the Act, all government departments along with the directorates and the subordinate office establishments are legally required to take measures for implementation of the specific provisions. Be it kindly noted that the Personnel Department, Government of Assam, has issued an office memorandum for reservation of posts for persons with benchmark disabilities. This is with regard to reservation. The Honorable Supreme Court of India is currently monitoring the compliance section by section of the Act in WPC number so and so, Justice Sunanda Bhandare Foundation versus Union of India, and a compliance report is required to be furnished to the Honorable Court by the Chief Secretary at regular intervals. The non-implementation of the RPWD Act 2016 by the states is being viewed very seriously by the Honorable Court. Therefore, given the importance of the provisions laid down under Chapter 4, Section 20 and Section 22 and its relevant subsections, and the strict monitoring of the implementation by the Honorable Apex Court, you are requested to kindly
Yes.
take the immediate necessary steps.
As far as creating a supernumerary post, it contains the implication of the finances of the personal department.
Of
The
course,
department, the PhD department only forward a proposal, Your Lordship. The finance and the personal department are the ones who carries out it. And as far as AJSL is concerned, this can be done. If she approaches the authority with the certificate, the authority will release a salary, Your Lordship.
then may I pray, Your Lordship, that the matter may remain pending. In the meanwhile,
Yes,
because
Mr. Gogoi. But it has to be done.
We have already moved the proposal at the records. It will be sent to the finance.
Have you sent it to the
Yes, Your
finance?
Lordship. We have sent a personal department, we have sent a finance department to everybody, Lordship. But moving expeditiously.
Huh?
nothing has been placed on record, Your Lordship. All these are verbal submissions being made before Your Lordship, but
Oh, we-
I have not been made aware as to whether anything has been done in my case or not, Your Lordship. That is my only grievance. I am running from pillar to post.
Okay, okay. Anyway, right. Heard,
R.S. Chaudhary.
Ms. R. H. Chaudhary, Senate Counsel for the petitioner. Also heard Mr.
R. Gogoi,
R. R. Gogoi for
PhD department, respond number 1, 2,
PhD department,
respond number 1 and 1, 2, 3.
for PhD department, comma, Mr. B. Gogoi for the finance department, comma, Mrs.
Yes, sir.
S. Sharma for who's 19 and 11? Who are they?
Department.
For the health department. Anybody here? Mr. JK, are you there?
Yes, yes, you know, there for the ART PPG department. Your
And
Lordship. The
Mr.
one who has created the
JK,
problem.
JK Goswami appears for the
Respond number 12.
point number 12,
Yes.
in the main petition, right? What's up? The petitioner. The petitioner's case. Is that he is working as an assistant executive engineer.
Her husband, Your
Petitioner's husband.
petitioner's husband.
Petitioner's husband is working as an assistant executive engineer in the PhD. Who met with an accident on 24/6/2009. The petitioner's husband was thereafter unable to rejoin his duty
Okay.
due to his medical condition. However, in terms of section 20(4) of the Right of Persons with Disabilities Act, 2016, hereinafter referred to as the 2016 Act, no government establishment could dispense with or reduce in rank, an employee who acquired a disability during his or her service. Further, if an employee after acquiring the disability was not suitable for the post he was holding, he could be shifted to some other post with the same pay scale and service benefits. That, and no, with a further provision that if it was not possible to adjust the employee against any post, comma. He may be kept on a supernumerary post until a suitable post was available, or he attained the age of superannuation, comma, whichever was earlier. Question. Question. As the petitioner's husband was not being paid his salary and other service benefits, the petitioner filed the petitioner's husband, the petitioner filed, huh?
The petitioner.
The
filed.
petitioner filed
Not-
WPC 7449/2022.
Yes, sir.
Next paragraph. WPC 7449/22 was disposed of
At the
by
most,
order dated 19/12/22.
nine, 12.
Huh?
Nine,
9/12, 9/12/22. By directing the secretary to the government of Assam in the PHE department to examine whether the petitioner's husband suffered from an accident on 24/6/2019, which resulted in him acquiring a disability, comma, which prevented him from attending to his duties. Question. If upon such examination, comma, the secretary found that the petitioner's husband had in fact acquired a disability, comma, appropriate orders was to be passed regarding the entitlement of the petitioner's husband. As per the provisions of section 20(4) of the 2016 Act. Next paragraph. As the direction passed by this court in WPC 7449/2020 was not being complied with, comma, the petitioner filed contempt case number 222 of 2023. Next paragraph. During the pendency of contempt case number 222 of 2023, the
Fund number, last page of it.
Deputy Secretary to the Government of Assam, comma, PHE Department issued letter number 30411/486 dated 20/03/2023, stating that the Secretary to the Government of Assam, comma, ART PPG Department had made an advice to act as per Rule 82 of the Assam Services (pension) close rules, comma, 1969 for sanction of invalid pension to the petitioner's husband and to act accordingly. Next paragraph. Being aggrieved by the letter dated 20/03/2023 issued by the Deputy Secretary to the Government of Assam, comma, PHED, comma, WPC number 2176 of 2023 has been filed by the petition. Next para. Mr. R. Gogoi, the learned counsel for the PhD department, submits that he has received instructions from the respondent numbers
From the deputy secretary, Lordship.
from the deputy secretary
Yes, Your Lordship.
to the government of Assam
PhD department.
PhD department to the effect that if the petitioner could produce a guardianship certificate from the office of the Deputy Commissioner, Kamrup Metropolitan District, correct?
Yes, sir.
The pay and allowances payable to the petitioner's husband as assistant engineer, assistant executive engineer, comma, would be paid to the petitioner. Full stop. Next para. The petitioner's counsel has today submitted a certificate of appointment of guardianship issued by the Deputy Commissioner, Kamrup Metropolitan District, dated 19/7/2023, which shows that she has been declared to be the guardian of her husband, Kamal Das, Shri Kamal Das. In view of the submission made by Mr. R. Gogoi, the petitioner shall approach the concerned who?
The approach is the deputy secretary, Lordship.
Deputy Secretary.
He will request.
The
Deputy secretary. Yes.
shall approach the deputy secretary to the government of Assam, PhD, along with a copy of the appointment of guardianship to enable her to receive the pay and allowances of her husband.
And Mr. Gogoi's role here.
Huh?
Further, then in that case, the supernumerary post which has to be created. Your Lordship.
Full stop. Next one. The above being said, Mr. R. Gogoi has submitted that a proposal for creating a supernumerary post has been made to accommodate the petitioner's husband, and forwarding letters in this regard have been sent to the finance department and the
Personal department. Lordship.
personnel department for creation of a supernumerary post. Write letter number, give me the letter number.
Personnel department was sent on 7/3/2000.
Where is the finance letter? Huh?
26/22 or 23. मुझ को तुम्हारा क्या कॉपी दिया ना 22, the proposal has been.
So
sent,
it
Your
is not,
Lordship. Since
no forwarding letters have been sent, only files have been sent.
Files have been sent, taking views, Your Lordship.
Where is the question of views now?
Because it was sent to the personal department, taking in views the supernumerary post, Your Lordship. Thereafter, the personal department forwarded it to the
No,
social
no,
welfare
no, no,
department.
Mr. Kaushal, that is beating around the bush.
Yes, sir. That's true.
You see, you have to take a decision as to whether supernumerary post has to be created. Now, once you take a decision, then you go for approval.
Yes, sir.
Otherwise, you're going to ask them for their views. They will ask you questions before giving their views.
Then ART PPG will come in and say.
No,
that
no,
Gogo
so
gave
this is
valid
all,
mention.
running around. It's like, a Hindi movie where you see all them running around trees. Nothing
So
really
let
helps.
let there specific direction for sending a proposal, the fine, personally,
Huh?
let be a specific direction for creation of supernumerary post.
You take a decision
Yes,
as
sir.
to whether the supernumerary post is going to be created or not.
Very well, Lordship.
In terms of 20,
Lordship,
What-
may I in that case just pray that subject to your Lordship's directions today, I will approach the authorities, let the matter be listed after 4 weeks and let them apprise your Lordships of their decision because
no, we're
otherwise,
not disposing of the matter.
then I'm absolutely obliged to,
No, we're not disposing of the matter. There's
Absolutely.
nothing of it.
I'm deeply obliged.
Whatever I said, the last sentence. Yes, I submitted that. I submitted that. The views of the finance department and the personnel department have been sought for by sending them files in the month of March and September 2022 with regard to creation of a supernumerary post for the petitioner's husband. The note sheets in this regard have also been produced before this court. This court is of the view that the note sheets do not reflect any decision of the PHED with regard to whether they would like to create a supernumerary post for the petitioner's husband. Accordingly, this court is of the view that the PHE department will have to unilaterally take a decision as to whether as to whether the petitioner's husband can carry on working and do the normal functional work required of an assistant executive engineer. Full stop. If the same is, if they come to a decision that the petitioner's husband is unable to do the normal work required of an assistant executive engineer, then they will have to take a decision in terms of section 20(4)
Second proviso.
of the
Second proviso. of
second proviso of
Section
section 20(4) of the 2016 Act
Lordships.
as to whether a supernumerary post has to be created.
Whether will not.
No, as to
For creation.
has
For
to
creation.
take a decision for creation
Lordships.
of a supernumerary post. Full stop. It is only thereafter that the approval for the same would have to be sought for from the personnel and finance department, personnel department and finance department. Full stop. The decision on the above aspect would have to be communicated to this court on the next date of hearing. On the next date of listing.
Lordship.
This is the matter after. This is the matter after 4 weeks.
Lordship, may I pray for a specific date, your Lordships? Prior to the vacation, I know your Lordships are putting it after vacation. Lordship, and this supernumerary exercise shall not be a bar for them to release some amount of money to me, your Lordships. If I place that national trust document, the guardianship document before them.
You see, 4 weeks, now today is 19,
Lordships,
20.
just
No,
19th,
4 weeks, so you see, I don't know, 1 month, vacation starts from 19.
like 19th itself, your Lordship, subject to your Lordship convenience, 19th or 20th is our
That
last.
is
working
all
day.
motion day,
20th
all
is not-
motion day.
20th is not. 19th. In that case, first November, your Lordships, as per your Lordship convenience.
This is a matter on, not first.
No, November, your Lordships.
This is the matter on, this is the matter on,
Yes, Amar-
7/11.
Very Lordship.
Deeply obliged.
Obliged, Lordship.
Give this up. Continue.
Yeah, please, the lordship. Lordship will be in order at page 8. Order was given by the Honorable High Court for provisional pension. And same has not been complied with. That is why.
Okay, right. Heard, Mr.
S.C. Dasman.
S.C. Das, learned counsel for the petitioner who submits that the order dated 13/3/23 passed in WPC 974/23 for payment of provisional pension has not been complied with. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by a registered post within 3 days. This is the matter after 4 weeks.
Allah.
I think we have filed an application for leave to file revision, my lord. We had taken steps by Dusty, my lord, as per your.
I don't know,
direction.
is there a provision where a person who is not a party can file a review?
That's why, my lord, we pray
No,
for
no.
leave.
No,
So
no,
what is-
leave is a different thing.
So for the subject matter of the read petition was concerned, it is particular to regarding settlement of the fishery is concerned.
We
And
filed
they are
it.
the person, a private person who is no related to the.
Madam, I think, no, I'm on a question of law. I'm not a question of just because you ask leave, it's for the giving. Or for the taking or for the asking or whatever. The question is, can a person who is not a party in the main case ask for leave or can he take part in the review? Why can't you file a appeal? Third party appeal. Third party appeal is allowed. I have not heard of a third party review. Can you give me instances of a third party review? If you can, well and good.
There is no bar, my lord.
No,
because
no,
we
show
are
me
not a
the law.
party in that
Please
case, my
teach me
lord.
the law.
And in the meantime. before
Madam,
that-
it's very easy for you to say there is no bar. Supposing I say there is a bar, then who is to be believed, you or me?
Then, my lord, let it come on Friday, my lord, we will place it.
Please show me the law. Once you can show me the law, then it's all right.
Well,
Okay, because I have to learn of.
yes, yes.
That part, no copy has been served to the impeded and the respondent, they will be served to the copy.
Okay, it is good. Here we are, we have to serve a copy, but we are not made a party to the.
You have not made a party and you are a party in the writ petition.
We are a party in the writ petition 728.
Lordship, actually.
We
there
have
are
filed only
number of
one review
petitions
petition.
between the parties, Lordship, most probably one appeal is
Okay, okay,
pending of
okay.
the same.
But this matter pertains to 520. 520.
Yes.
So that is a question. You,
Both the cases were decided by same order.
acha,
Common order.
common order.
Same issue involved.
Say between anyway, so you want the review to be held in both the cases.
No, only 520.
If only one case. is
520,
decided,
so you are not there in 520.
But order was a common order.
Common order.
How does it
Same
matter?
issue
But
involved.
520, she's not a party. How does it affect you?
Same issue involved.
Only problem is, like I said, you have to show
Yeah.
that a third party review can be filed.
Yes.
If you can show me that, that's it,
Also.
then it's not a, it won't be a problem.
Well, we are going to need to come up on Friday because they have already issued tender and the tenders have been reopened. It may be.
What was the bar for you to file a third party appeal? Why did you?
Why is barred for the website?
An order was passed by the honorable court and the government has come with an eye for seeking extension of time to complete the process of the settlement. An honorable court directed the respondent to anyhow complete the process by 15/9/2023, including the.
15/9. So that's over.
59 and already settlement is going on, order is being passed.
Well, the committee, the constituted by the government to define and redefine the fisheries, my lord, falling under national forest, my lord. The committee recommended that the scheme is not viable for commercial.
Madam,
fishing and
I
it should
think
be
the
closed.
easiest thing for you is to file a third party appeal. and say that I should have been heard.
But let it come on Friday, my lord, if I can satisfy your lordship, definitely, my lord.
Okay, right. On the prayer of Miss U Barwa, Learned Senior Council is the matter on Friday. Friday or next Monday, madam.
My lord, let it be on Friday.
Next. Yes, what is this?
Also, the interlocutory application is filed for correction of the cost title lawsuit.
Ah,
Uh,
what is the correction to be made?
correction lawsuit instead of the respondent number, Ministry of Labor and Employment lawsuit, it should be Ministry of Labor and Employment, Ministry of Skill Development and Entrepreneurship.
This is respondent number?
Lawsuit, respondent number lawsuit, respondent number one.
Respondent number one is state of Assam.
State of Assam, yes. Lawsuit, yes.
There is no ministry. What are you talking about? Give me the main dictionary.
3-4.
Huh? Three is Commissioner Secretary, Finance Department.
Yes.
Number 4 is Director, Employment Assam. There is no ministry involved.
Lawsuit instead of respondent number one lawsuit, the department is shown as Ministry of Department of Labor and Employment.
This is Mr. Council.
It should be
Respondent-
Department of Skill and Employment and Entrepreneurship.
Mr. Council, please, respond number 1 is the state of Assam. Ministry is only relatable to Union of India. So this is state of Assam. Where is the question of ministry coming in?
Lawsuit, the state of Assam, lawsuit, the department should be lawsuit. Department of Skill, Employment and Entrepreneurship.
Okay.
Instead of Department of Labor and Employment.
You have, then you please correct your petition. You have said ministry, come to para 2 of your application.
That is a lawsuit history, lawsuit. When the departments were bifurcated.
Actually, it should be Department of Skill, Employment and Entrepreneurship. Correct?
Lawsuit.
Okay, right. Heard, Mr.
SK Das.
SK Das Learned Counsel for the applicant who submits that a correction may be made to the cost title wherein instead of Department of Labor and Employment, the same should be amended to Department of Skill, Employment and Entrepreneurship. That is in 1 and 2 basically.
1 and 2.
Who's for the other side? Mr. Yes, what is your name?
CKS Barwa, lordship.
Mr. C.K.S. Barwa and Mr. B. Gogol. Submit that they've got no objection to the application. First of accordingly, the application is allowed. The applicant is allowed to amend the cost title of the respondent of the cost title by showing by correcting the cost title of respondent or by correcting the address of the respondent number 1 and 2 as Department of
Skilled employment.
Skill, Employment and Entrepreneurship instead of Department of Labor and Employment. The corrected cost title may be filed by the applicant within 2 weeks.
No, already we have filed this amendment, interlocutory application that registry will correct the cost title.
No, they'll have to file a corrected cost title.
Yes.
It has to go on the CIS
We will file.
and the IS accordingly disposed of. You have to file a fresh cost title. Otherwise, I could have asked you to file a fresh repetition act. Yes, what is the correction to be made?
Yes, and it was, the name of the respondent number one is, Managing Director, Food Corporation of India. The correction is to be made, Food Corporation of India, represented by the Managing Director,
Oh, okay. Okay, right. Heard, Mr.
G.K. Gupta.
G.K. Gupta, learned counsel for the applicant, who submits that the cost title pertaining to the respondents, pertaining to the respondent number one, needs to be amended by changing the respondent number one from the managing director, Food Corporation of India, 16-20 Barakamba Lane, New Delhi -11001 to the Food Corporation of India, represented by the managing director, FCI 1620 Barakamba Lane, New Delhi 110001. What's that? Miss
B. Bora appearing on behalf of BK Singh.
Mr. B. Bora appearing on behalf of Mr.
BK Singh.
B.K. Singh,
Standing
counsel for standing
FCI.
counsel for the FCI,
Yes.
submits that she has got no objection to the prayer made by the applicant's counsel. Accordingly, the prayer is allowed. The applicant shall submit a fresh cost title showing the necessary amendment / correction made to the respondent number one. I is accordingly disposed of. The correction made to the respondent number one as indicated above.
And the case is also this read petition is also listed,
Okay. And the writ petition, what do you want?
2921.
Yes, how much time do you want, madam, to file?
Actually, my lord, we have not received any instruction from the department.
How much time do you want?
So, 6 weeks.
Miss so-and-so appearing for so-and-so, huh? For the FCI. It is granted 4 weeks time to file affidavit in appointment. This is the matter of the case. Yes, what is this?
My lord, review has been preferred, my lord, being agreed, my lord, the order.
How many days delay?
My lord, many years, my lord.
Let me see the, what is this? What is
Order of
this?
1994, my lord. Yes, my lord, that petition was preferred, my lord, by husband, my lord. My husband, nowadays, my lord, he expired, my lord. But my lord, for date order, my lord, I am not.
You are challenging what, your termination?
My lord, termination was challenged, but my lord, during the pendency, my lord, termination was withdrawn. And my lord, my husband instructed the engaged advocate, my lord, to not to press, my lord, or withdraw. My lord, he did not withdraw. There was adverse order of passed, my lord. And my lord, 2021, my lord, my husband died, my lord, and before that, my lord, he discharged service, my lord, more than 14 years. So, my lord, if I order, my lord,
Good case for dismissal.
yes, if I succeed, my lord, then my lord, I will get.
I doubt you will
pension.
succeed.
Pension.
Very difficult to succeed in the first round itself. Heard Mr. S. Chauhan, learned counsel for
No
the petition.
explanation as such, lord.
Heard Mr. S. Chauhan, learned counsel for the petitioner, who submits that there is a delay of 5374 days in filing the review petition against the judgment and order dated 21/7/2006.
31/7. 21/7. Yes.
21/7/2006, passed in CR number 2828/1996. Wow, we'll dispose it of here in there.
Yes, lord. No, my lord, technicality is there, my lord. It was It was, my lord, bar because of, my lord, my husband, my lord, was dismissed from service. He challenged, my lord. Thereafter, my lord, thereafter, my lord, his dismissal was withdrawn, my lord. And my lord, my husband instructed, my lord, to withdraw the petition.
When did your husband die?
It died, my lord, 2021, my lord.
21 lordship, 15 years, is it?
First up.
21, my lord.
Even if there is suffering cancer and all these things, lordship, but 15 years is a too long period.
No, 15 years, technically it is not, my lord. Can you see, my lord, death certificate? I have annexed, my lord, annexure 11, page 39 of the review petition, my lord. He died, my lord. Sorry, my lord. Page 38. He died on, my lord, 16/10/21. Annexure 10, my lord. 16/10/21. Because his lifetime, my lord, I could not, my lord, file. I could not, my lord, file because there is bar, my lord, because my lord, my husband was there, my lord. After his death, my lord, only, my lord, I am competent to file this review petition because I am agreed, my lord, because I will not get pension, my lord, family pension. So this matter ultimately, my lord, relate to family payment of family pension, my lord.
Your husband service was terminated.
Yes, the husband was terminated, yes.
Then, he was what, working as what?
He was driver, my lord, in the department of Assam Accord Implementation Department, my lord. And the dismissal was withdrawn, my lord. Then he, my lord, continue.
So he was terminated. Then what else?
The terminator was withdrawn, my lord.
Huh? Terminated was withdrawn? What do you mean
Yes, yes, my
terminated?
lord. My lord, the page can you see page 20, my lord.
No, I cannot go, right.
My lord, page 20 withdrawn. Can you see, my lord? Withdrawn.
And 14 years, 3 months, lordship, this is also not for government servant. The calculation of pension is 20 years.
10 years,
lordship.
my lord, 10 years, my lord, because he was a suspension for a regular employee, my lord.
You have been terminated, Mr. Council, that's all.
Yes.
Termination was withdrawn, my lord, page 20, my lord, can you see? Page 20, my lord, annexure 3 of my review petition, my lord.
You see, if it was withdrawn in 1994, then why did you go to court in 2006? I mean, why did you go to court in 1994?
My lord, order was immediately challenged, but my lord, since my lord, it was withdrawn, my lord, my husband instructed the Lord's Council to withdraw the petition because no, my lord, really, no grievance remained. But my lord, it was engaged counsel, he did not withdraw the petition, my lord, that was why, my lord, ultimately the civil rule was dismissed.
So your withdrawal, your dismissal was withdrawn.
The dismissal withdrawn.
So
and-
this fact was not communicated to the court.
Yes, my lord, this is the technicality committed by my earlier engaged advocate, my lord. My lord, I will not fix another date, my lord. I will not, my lord. I satisfy you, lordship, my lord, and you lordship may fix the date.
And for any service, lordship, government of 14 years is not the pension cannot be disbursed, lordship. At least 15 years and 20 years, lordship, then though.
No, 10 years service is requirement.
No, there is proportionate pension can be given 10 years. Proportionate pension can be given 10 years.
Lordship, fix another date, my lord. I will satisfy lordship, my lord, because my, this is not, because my lord, technically, my lord, it should be counted from my lord 2021.
But he also never,
2021.
But
he
he
also
never
never
applied.
came lordship
He
for
never came.
15 years.
He never came, his wife had
Yes,
come.
wife has now come.
Yes.
If he was entitled lordship, he should have come at that time lordship. Regarding withdrawal and filing of writ petition, this is different thing lordship. And it cannot be assumed that since 2006 to 21, he was bedridden.
No, my lord, can you see my husband, my lord? He was, my lord, trying his best, my lord. Thereafter also he filed, my lord. Another repetition, my lord, kindly see page, my lord, 34. Page 34, my lord. There, my lord, another repetition filed, my lord, while, my lord, I was released. But
Filed by whom?
by my husband, my lord. And my lord, there is observation, my lord, in this case, my lord. Actually, my lord, it was a wrong petition filed, my lord. It should be, my lord, filed a review petition, but my lord, a read petition was filed. Honorable Justice Gogoi, my lord, the observation is there. However, the petition, page 37, my lord, I am reading. However, the petitioner will be at liberty to seek.
Just a minute, Mr. Council, please give some,
My lord.
relax. Just, you see, I cannot read and hear you at the same time.
Well,
The petitioner will be at liberty to seek review, recall the order dated 21/7/2006,
yes, ma'am.
passed in civil rule number so.
Well,
So,
petitioner mean my lord.
just a minute. I don't think you've got any case.
And there's a temporary lordship appointment.
My
is
lord,
temporary.
Huh?
The appointment is also temporary lordship.
Page,
not temporary, my lord, not temporary, my lord. I am saying, lord.
page,
Page
page.
33 of the writ petition lordships. The driver on a temporary basis lordship.
What is this 2828? 2828 is again, Ah. In compliance with that order.
Yes,
So he cannot say that he does not know about that order.
yes, lordship.
My
This
lord,
is there.
it was, my lord, my husband. I am.
No, no, husband,
wife,
15
my
years, what he did, lordship.
Okay, right. Whatever I stated. He submits that civil rule number 2828 of 1994 had been filed by the petitioner's husband on the ground that the petitioner's dismissal from service was arbitrary. However, during the pendency of civil rule number 2828 of 1994, the petitioner's dismissal from service by order dated 31/5/1994 had been withdrawn. Had been withdrawn. Where is the withdrawal letter?
My lord, written page 20.
Had been withdrawn. By
Order dated second.
office order dated 2/8/1994, issued by the state respondent. However, though the petitioner's husband had informed their counsel to withdraw civil rule number 2828 of 1994, the council had not withdrawn the same. Civil rule number 2828 of 1994 was thereafter dismissed as being devoid of any merit by judgment and order dated 21/7/2006. Next paragraph. The petitioner's counsel submit that the petitioner's husband had been in service for approximately 14 years, 3 months, and as such was entitled to receive proportionate pension in terms of the Assam Services Pension Rules 1969. He submits that unless a review of the judgment and order dated 21/7/2006 passed in CR number 2828 of 1994 is allowed, is allowed, the petitioner would be losing family pension, proportionate family pension, which is a right that has accrued to the petitioner. Next paragraph. The counsel for the petitioner also submits that the petitioner's husband expired on
My lord,
21 lordship,
on 16/10/2021, page
16/10/2021. And the present petition for review has been filed on 8/9/2023. He submits that in view of the reasons stated above, the delay in filing the review should be condoned. Ms. M. Bhattacharjee, appearing for the state respondents, submits that there be a delay of approximately 16 years in filing the review petition. That also after the death of the petitioner's husband, the review petition, the condonation of delay application should be rejected. I have heard the learned counsels for the parties. The judgment and order sought to be reviewed had been passed on 21/7/2006 in CR number 2828 of 1994. Subsequent to CR number 2828 of 1994, the petitioner's husband had also filed WPC 259 of 2008, which had been disposed of by order dated 22/02/2008. In the order dated 22/02/2008, passed in WPC 259 of 2008, this court had also given liberty to the petitioner's husband to seek review/recall of the order dated 21/7/2006, passed in civil rule number 2828/1994. And thereafter to approach the departmental authority in accordance with law, if so advised. The above being said, the just before this sentence, just put, the government of Assam implementation of Assam Accord Department in its office order number IAA 34/93/43 dated 24/9/2007 had released the petitioner's husband. No. Had released the petitioner's husband from service in compliance with the order dated 21/7/2006, passed in CR number 2828 of 1994. The said office order also categorically states that the petitioner's husband had been appointed on a temporary basis, while order number IAA 44/92/48 dated 6/1/93. The judgment and order dated 21/7/2006, passed its CR number 2828 of 1994, also records the fact that the petitioner's husband had been temporarily appointed as driver against a newly created post, the white order dated 6/1/93. Then you write this, then that. All the above orders and orders clearly show. No, show that, not so clearly say, show that the petitioner's husband had been appointed on a temporary basis and was not appointed on a regular basis. As such, there could have not there as such there was no question of payment of pension in terms of the Assam Civil Service Pension Rules 1969, as pension could only be paid to regularize government servants. Next paragraph. The above being said, there is no reason given by the petitioner as to why there has been an inordinate delay of nearly 16 years in challenging in filing a review against the judgment and order dated 21/7/2006, passed in CR number 2828/1994. Further, the petitioner's husband having been given liberty to challenge the impugned judgment and order by order dated 22/2/2008, passed in WPC 259 of 2008. There is no reason given for coming to this, coming to this court at this late hour. Accordingly, there being no valid ground, there being no sufficient cause made out for reviewing the impugned order passed in CR number 6868 offense. Besides there being no merit in the petition, as the petitioner's husband was a temporary driver. The application for condonation of delay is rejected. Please dismiss.
Yeah, my lord, order required perfect matter in review petition, my lord.
Huh?
One order is also required in the review.
No, in the review, right? In view of the, no review, there's no numbering given. No numbering given in the review. That is only filing number given. You see, you had no case for the simple reason that the orders passed by the court and by the, shows that you were temporarily appointed, not the regular appointment. 49. Yes, what is this, madam?
Wait, please, Lord. Lordship, the engaged council is out of station. Kindly pass over the matter for that.
Okay, what do you want out here?
We file our affidavit, my lord.
Okay. Miss
Ebora,
Ebora
NHM.
for the NHM is granted
2 weeks time.
3 weeks time to file affidavit in opposition. This is a matter of 3 weeks. What to do? I think I have to. And we have one steno less today. Anyway, I think maybe we'll go faster some other day.
Okay.